May I, Lordship, I beg to mention item number 9. Uh, on behalf of conducting counsel for appellant, he is out of station due to some personal difficulties. Matter may be listed.
9 is stable 8.
Lordship, 9 and 8 arise out from same.
Same judgment.
Yes.
The learned counsel, Mr.
T. Dodung, on behalf of K. Tama.
Pleading for the learned counsel, Mr. A. Tama. Submits that the learned conducting counsel is not available today. And on the ground of adjournment, we wait for. You are for?
Item number 8.
What is your name?
Beor.
In item number 8, so and so, they pay for the appellant. The hearing is adjourned today on the request of the learned counsel for appellant. When do you want it?
After 3 weeks.
This after 3 weeks for hearing. 8 and 9 same one. 8 and 9 same one.
That's all, bless.
May I only. And I'd like to mention item number 7 on behalf of MD Sivas. And conducting counsel is having some difficulties, so Your Honor may kindly fix this matter on Thursday.
Ginny is there.
I'm for respondent number 2, Lordship.
Legal aid counsel.
Yes, Lordship.
What is your name?
H. Thai.
Mr. H. He paid for the appellant. The learned counsel has submitted that the learned conducting counsel, Mr. M. Resource is not available today. And on the ground that adjournment has been paid for. I have also heard Mr. G. Gini, the learned legal aid counsel, paid for the respondent number 2. The hearing is adjourned accordingly. Next after 2 weeks.
No, Your Honor, kindly fix on 27
27 of what?
March this month.
March not possible.
So
27 March not possible.
and
Month of April.
April, kindly counsel is from outside of the state, so kindly fix date may be given now.
3rd April.
3rd April. Congratulations.
3rd April. For hearing. Yes.
Lordship, here, what I find is the dissenting counsel for the Union of India is not present.
Yes.
In fact, yes. Then we'll start, Lordship. Then we'll start.
My Lord, with great respect, my Lord, the writ petition was filed by me. It was on the concession of Neris, the appellant. The order was passed, not once but twice. Union of India has absolutely no role, my Lord. This was a order passed on concession, my Lord. This writ appeal is not at all maintainable.
So we will go for a hearing on the point of maintainability.
My Lord.
Then you may start, Lordship, why it is not
We
maintainable.
will go for a hearing on the
Lordship.
point. Other senior counsel, Mr. A. Apanku, assisted by MS.
Leading.
Preparing for the appellant.
With AC, no party.
Appellants. Funding is for 1, 2,
For private respondents, my Lord,
all private respondents.
yes.
Yeah. How does the funding? If it's
1,
for
2, my Lord. 8, my Lord.
1 to 8, all the private respondents.
Yes.
Malad, I am representing respondent number 9. Ladies comes under the malad, the respondent number 9.
No,
Ministry of
Heard
Immigration.
Mr. M. Katir. He paid for respondent number 9. Then who is for 1, 2? Oh,
1 to 8, my lord, I appear.
oh, you are
1 to 8.
1 to 8. Then Kapil is for 9.
Yes.
Uh, Mr. Panging has raised the issue of maintainability of this appeal. Therefore, when do you want it?
Next week, my lord.
Next week. Lease this matter next week for hearing on the point of maintainability of this appeal.
No. All right.
May I please your lordship? Lordship, the petitioner before your lordship is challenging the judgment and order dated 4/12/2024 passed by the learned single judge whereby the cancellation of allotment order in respect of petitioners was not interfered. On the ground that lordship, the land falls within the Itanagar Wildlife Sanctuary. Lordship, what if the brief fact of the case is that the petitioner, being a officers club, Itanagar club, occupied some plot of land at this sector, Itanagar, since 1980s. Initially, they occupied a plot of land measuring 600 square meter at this sector.
This appeal was directed to be listed along with another 2 appeals.
No, Lordship, it was wrongly
11.
listed, Lordship, Mayor. It was wrongly listed on previous occasion. But since these writs are nowhere connected with that earlier 2 items, that's why this writ petition has been segregated, Lordship.
The appeal number 7 was segregated.
Lordship, there was that writ petition, Lordship, there was a direction from the principal bench to list that particular writ appeal along with the writ appeal 7 of 2025, which was filed before the principal seat. But when the matter was sent back to this bench, this honorable bench, now that writ petition number 7 became a writ appeal number 11.
Oh.
So this writ, my writ appeal, this number 7 of 25 was wrongly listed along with that writ appeal. Accordingly, on previous date, since both are nowhere connected, so that both writ petition were
This appeal is
segregated,
Not yet admitted. This
not
appeal-
been admitted.
Not yet. Who is for the respondents?
I'm for the respondents.
Respondent number 1.
Now it'll be for all,
All respondents.
yes.
All land.
Other this thing, land management, they had this thing, any council. Now they'll be taken up by us.
So you are paying for all the respondents.
All respondents. Private respondents also there. My lord. Thank you. 1 to 5, Mr. Singh.
1 to 5.
Yes, 5 and 6 are private.
Performer respondents are also there.
6 and 7, Lordship, they are the performer respondent. In fact, they are not required because in writ proceeding, they declined to participate. They didn't participate in the writ proceeding.
When the proceeding they did not participate.
Yes, sir. Despite of service served upon them through the justice service also. So accordingly, on previous day,
Today we will admit the appeal.
and Lordship, in the meantime, I have a interim prayer. Lordship,
Interim prayer will be considered on the next date. Heard Mr. K. Lolen, appearing for the appellant. Heard Mr.
And lower. And lower.
Appearing for the respondents 1 to 5. Mr. Nolan submits the respondents 6 and 7, comma, in spite of receiving notice, comma, did not appear in the writ proceeding. Therefore, no notice is required to be sent to the respondents 6 and 7. Leave this matter
after 1 week, Lordship,
after
because I have an interim prayer, Lordship.
Next week.
Next week.
Later next week. On the next date of listing, the prayer for interim order shall be considered.
In plea of license.
Number 3.
Well, the basic
Yes.
challenge in this writ appeal is against the impugned judgment order dated 27/2/25, passed in writ petition number 233 by Honorable Single Judge. The lease involved in that particular writ petition, my lord, was relating to the allotment of petrol pump, my lord. Now, the two issues, it was under the category 1, ST category, my lord, just before I take the impugned order. Then what had happened, the interpretation before the honorable court, before the honorable single judge came up for two reasons, my lord. The first is whether the applicant meets the criteria prescribed under 4E and F of the brochures of that eligibility criteria. The first issue was the availability of the land certificate, which is issued by the EAC, circle officer, and which they have said, no, this does not come under Rule 143 of the AP Land Record Settlement Act 2012. And therefore, then, my lord, what had happened? That is not the case, my lord. Then this impugned notice came saying that, no, you have not fulfilled the criteria. Then, my lord, the honorable single judge committed a manifest error in law is on two counts, my lord. One, my lord, under section 4 of the AP Land Record Settlement Act, my lord. There it says ki circle officer is also known as the revenue officer, my lord. But here the honorable court says, no, it is not. Now, therefore, what had happened? In a similarly situated, my lord, one writ petition, in one writ petition, Honorable Justice Medi passed the order, said the land certificate is issued in terms of OAM dated 1988. Now, the principle laid down in that particular law has not been negated, because therefore there is a violation of principle of binding principles. And Lordship, I am placing this judgment. So therefore, this is the quarrel in this particular writ appeal. Now, my lord, kindly come to the impugned order. I'll just point out without page 139 of the order.
There were two different views.
Yes, the honorable single judge took a different view from the coordinate bench. My lord will kindly come. The fact, everything I will not read. It's at page, it starts from page 139, my lord.
139.
This is the impugned order, my lord, that I will.
Yes.
My lord will kindly come to page 142, paragraph 4 onwards. We read for a moment, lord. 142. Yeah. The impugned decision being the bone of contentions, more particularly the reasons thereof, are quoted here and below. There, sir, please refer to your application received by us, application form number so and so on the subject. Please do refer to our letter dated 13 December 2023, and wherein you were advised to submit certain documents. Now, the first is LPC. They said ki LPC not available. Land availability certificate is not valid as per provisions of Rule 143 of Arunachal Pradesh Land Settlement and Records Rule 2012, emphasized by this law. Now, Lord, this is the bone of contention in this writ appeal law. Now, Lord, kindly come to para 6. Thus, the aforesaid, para 4, para 5, sorry, page 143. Thus, from the aforesaid, the grounds for rejections are relatable to two conditions, that is, want of land possession certificate LPC and land ability certificate, which is not valid as per Rule 143 of the Arunachal Pradesh Land Settlement and Records Rule. My lord, the answer is clear because land possession certificate, my lord, is not issued under the Arunachal Pradesh Land Settlement and Records Act. It is by OAM dated 1988. My lord will kindly come to page 123 for a moment to relate it. This is in their government affidavit, my lord. Huh?
Yes,
Page, NHRC page 121, my lord.
121.
121 it starts. My lord, issue of, kindly note this, office memorandum number LR 31/84 dated 9 December 1988. My lord. Issue of land, issue of possession certificate, procedure thereof. But these is the rules which governs, my lord, the issuance of the land possession certificate in Arunachal Pradesh. My lord is aware in Assam we have land patta system, or we call it Myadi patta, I suppose. That is, so there is a separate rule for issuance of the patta here, my lord. So that is in the form LPC. Now, therefore, the first count the honorable single judge has faulted with is in the finding is this, my lord, because he could, the honorable single judge could not appreciate this aspect of the matter. And to fortify my argument, my lord, kindly come to this particular judgment, my lord, page 154, my lord. The coordinate bench has held on this particular proposition of law, my lord. My lord will kindly come to page 156, paragraph 5, my lord. This paragraph 5 is the fact connected therein is similarly situated. Sri so-and-so learned counsel for the petitioner has submitted that the issue concerned is a trivial one, as the impugned order has taken into consideration the LPC, which was submitted at a subsequent point of time. He has submitted that irrespective of issuance or submissions of the LPC, there was no dispute with regard to the fact that petitioner had owned the particular plot of land. Here also, I own my land. In this regard, the learned counsel for the petitioner has drawn the attention of this court to the certificate issued by the dealer as well. That is what I referred to, my lord, section 4 of the Land Settlement Act. Circle officer is also defined as a revenue officer. West Cumming District dated 26/9/2023. In the said certificate, the survey number was specifically written as BR number so and so. Along with said certificate, cadastral map was also enclosed, by which the identity of the land could be ascertained. He submits that it is only due to bona fide intention that the petitioner has subsequently submitted the LPC, which was issued in the meantime. Here, my lord, I also respectfully admit that after the land availability certificate, I have also submitted my land possession certificate subsequently pursuant to that impugned email, my lord. Now here, Sri so-and-so, next page, my lord. Meantime, on 1st February 2024, and therefore, there was no dispute or confusion raised on the identity of the land or the ownership of the petitioner of the land in question. Sri so-and-so learned counsel has also referred to the Arunachal Pradesh Land Settlement and Records Act 2000, hereafter referred to as the Act 2000, more specifically Section 4H, my lord. Now, this is the crystal clear finding by the coordinate bench, my lord. So, my lord, kindly come to paragraph 6, my lord, paragraph 6, bottom last 4 lines, my lord. In the instant case, my lord, in the instant case, the last date of submission was 17/10/2023, whereas the LPC is admittedly dated 01/2/2024. He therefore submits that the impugned decision which has been conveyed by email dated 07/02/2024 cannot be termed unreasonable, as the relevant factor have been taken into the considerations. Now, this was their submission, my lord. The government side today also, the London Deputy Solicitor General is here, my lord. Now, kindly come to paragraph 10, which stands at page 158, my lord.
Yes.
The learned counsel for the petitioner has emphasized that the certificate issued by the dealer also would sufficient to come to a conclusion of ownership, as the said officer is one of the revenue officer as per section 4 of the Act of 2000. This court has examined the said certificate along with cadastral map vis-a-vis the LPC, which has been subsequently issued on 1st February 2024. The certificate dated 26/9/2023 contains survey number bearing so and so. The LPC, which has been annexed to the REIT petition, also contains the same survey number. It is also not the case of respondent corporation that there is any dispute with regard to the ownership of the description. Similarly situated, my lord, the lordship made his finding, my lord, others on the same pedestal and the same fact. Now, therefore, my lord, in the para 11, concluding, my lord, will come. Though in a given case, subsequent document may not serve the purpose that it may not be within the requirement of the advertisement in the instant case. So far as the claim of the petitioner as Group 1 applicant is concerned, same is duly filled by certificate dated 26/9/2023 issued by the DLRSO and the fact that the same was submitted along with the application. As noted above, there is no dispute with regard to the identifications or ownership of the land in question by the petitioner. As pointed out by the learned counsel for the petitioner, the Act of 2000 recognizes DLR as a revenue officer and Section 6 thereof lays down the power of such officer as per which a certificate of present nature can be issued. Now, therefore, this order came into. And this particular finding, my lord, has not been negated by the Honorable Single Judge while passing the impugn order dated 27/2/2025. Now, what the law says on this, unless the coordinate bench finding is not differed with and give reasons, in that even it ought to have been referred to the larger bench. My lord, can you pardon those judgments? My lord, kindly see this National Insurance Company case in 2017, my lord, 16 SCC.
Setty's case.
Yes, Setty's case, my lord. 2017, 16 SCC, my lord, page 680, paragraph 20 to 21, 17 to 21, my lord. It's very loud and clear. My lord, I furnished this. Let me read this for a moment, my lord.
I have read it.
Yes. So therefore, my lord, one paragraph, 21, let us refresh together. 21, my lord. Can you give me? Have you given the book? Hey, sorry, my lord, I apologize, my lord, my younger has not brought paragraph 21, my lord, kindly. Yeah. Now here, my lord, it is a doctrine of binding precedents.
Para 21.
Para 21, my lord, 16 to 20 is relevant, but still page 699, my lord, of the citations.
21.
Yes, para 21.
Hmm.
In Chandra Prakash, yes, Mother, I read for the convenience of the court, Mother. In Chandra Prakash versus State of UP 37, another constitution bench dealing with the concept of precedent stated thus: the doctrine of binding precedent is of utmost importance in the administration of our judicial system. It promotes certainty and consistency in judicial decision. Judicial consistency promotes confidence in the system. Therefore, there is need for consistency in the enunciation of legal principle in the decision of this court. It is in the above context, these court in the Raghuvar Singh held that a pronouncement of a law by division bench of the court is binding on the division bench of the same or smaller number of the judges. Paragraph 16 talks about, my lord, how if you don't negate, it should refer to the larger bench. My lord can have para 20 also. 16 to 20, my lord, these are all, it talks about the binding precedents, my lord.
Even if the earlier judgment was wrong, then also it has to be followed.
Correct, my lord, para 16. On that proposition, my lord, let us read para 16, my lord. An earlier decision may seem to be incorrect to a bench of a coordinate jurisdiction, considering the question latter on the ground that a possible aspect of the matter was not considered or not raised before the court, or more aspects should have been gone into by the court deciding the matter earlier. But it would not be reason to say that decision was rendered par in curiam and liable to be ignored. The earlier judgment may seem to be not correct, yet it will have the binding effect on the later bench of coordination jurisdiction. So therefore, my lord, this Honorable Justice made the Justice Medi's judgment, my lord, that was rendered in WPC number 72 on 5/2/2025. That's binding unless there is a different view. So, my lord, it is kind of in the criminal jurisprudence, we call this exculpatory evidences and all. So unless these are not there, you cannot press into. So therefore, my lord, my respectful prayer, kindly interfere with this order and then fix it, the matter for stay this. And my prayer is, my lord, kindly come.
And Kato is for
My lord, I'm for respondent number one only, my lord.
only one.
Yes, my lord. And moreover, my lord, we have no role to, my lord, play.
Nothing much, my lord.
My lord.
Who is for two?
Respondent number, my lord,
They,
2 and 3 is the, my lord, main
My lord, yes,
respondents.
notice will go.
my lord,
No,
my lord, my lord, what had happened yesterday, after filing this writ appeal, my brother Tapak is there, who was representing this matter in the single bench. Now, my lord, even if we see order 3 of the CPC, if a previous counsel has appeared in a single court, he is bound to receive that. But without power also he can appear. But here he has refused, saying that let notice go. So is a good opportunity, my lord. Kindly interfere with this and stay the operation and fix it for the hearing, my lord. Let them come with the affidavit, what they say. But it's a question of law only, my lord.
Heard Mr. T.T. Tara, appearing for the appellant. Heard Mr. M. Kato, the learned Deputy Solicitor General of India, appearing for the respondent number one.
Well,
It is better to issue notice.
Well, otherwise they are going to re-advertise, my lord. We have made a categorical statement that no re-advertisement has been done. Or, my lord, kindly status quo.
I will state a judgment.
Great.
Issue notice to the respondents 2, 3, and 4. The appellant shall take steps for service of notice of the respondents by registered posted agent. Least after 4 weeks till returnable date. What is the
Operation of order dated 27,
till returnable date? The operation of the order dated
27/02/2025,
27/02/2025.
pass in read petition.
Passed in writ petition number. Where is the number?
Yes. But a clear portion, my lord, will find at page 50.
39.
Yeah.
Is 130. 130. 130. It will be here. 139. The petition number 233. Operation of the order. Passed in WBC
Number 232.
232 of 2024. Shall remain state. Until further order.
Great.
Wait, please, your lordship.
Yes.
My lord, I mean, item number 4 and 6, these are connected appeals, my lord, by the same appellant.
Four,
All
4,
4 and 6.
but 5 is also listed along with.
5 is also listed, no, he's there. My lord, although, my lord, it has been listed, 4 and 6 have been listed for orders, my lord, but there is already an order passed by this honorable court on the last occasion that the service is complete and therefore the endeavor shall be made to dispose of the writ appeal today. So if your lordship permits, my lord, in that case, I can start with the argument.
Today it is for orders only, so.
That is true, but if your lordship will kindly see the previous order, I am on a very short point, my lord. Previous order, my lord, the last line, it is also observed that an endeavor shall be made to dispose of the appeals on the next date.
Okay.
I am on a very short point, my lord.
Okay, yes, please.
Now, I'll just give your lordship a brief genesis, my lord, how this case arose. There was an advertisement by the Arunachal Pradesh Social Empowerment Department, my lord, floating a tender inviting supply of certain items. That was done in the year 2024. 4th of March, my lord, I move a writ petition before this honorable court saying that certain conditions in the tenders are illegal, arbitrary, and contradictory. 4th of March, this honorable court passes an interim order, requires them to place on record the basis for incorporation of those conditions. Well, their writ petition proceeds. 10th of March 2024, they issue a corrigendum and they further restrict the conditions. I challenge the corrigendum in a separate writ petition, which is item number 6. I challenge the corrigendum in a separate writ petition. On 7th of June, this honorable court passes an interim order staying the operation of the corrigendum. And that interim order continues till disposal of the writ petitions. Now on 24th of July, despite the fact that there was an order of stay operating, 24th of July, my lord, they select 2 candidates, 2 entities, and attempt to award the work order to them. These 2 candidates are the private respondents who did not contest the writ petition. And in the appeal also, they are not contesting. Now, after the work orders were issued, I amend the writ petition, this particular case from which this appeal arises. I amend the writ petition. One of the grounds I specifically take in the writ petition that since there was an order of stay operating, the selection of these 2 candidates could not have been done. Without any leave of the court, how can you allow and to allot the work order to somebody? Now, in the amendment application also, after the writ petition is amended, the honorable court permits me to amend the writ petition. I file an amended writ petition. The state does not file any affidavit in the amended writ petition. In the other writ petition where I challenge the corrigendum, there also the state did not file any affidavit. And it is in that circumstance the case goes for hearing. My case before the honorable court in the writ appellate bench was that since there was a specific order requiring the respondents to put on record the basis on the basis of which the conditions were incorporated, and those were not done, the honorable single judge committed an error in finally dismissing my writ petition because the basis was not there. Even assuming, my lord, that they could explain the irregularities or arbitrariness and illegalities, the fact of the matter remains that there was a stay order operating against you. How you do the selection? So, on consideration of these submissions, my lord, the honorable court passes an order that the first order by which, my lord, the order in the writ appeal has been stayed, my lord, that your lordship will find on 9th of January order. 9th of January in this writ appeal, my lord, 9th of January order. Your lordship can kindly come to page 5, paragraph 8. These are categorically noted by the honorable division bench while granting me an order of stay. That maybe in the IA file. IA file is also in the.
In the IA file.
Yes, maybe in the IA file.
IA number 63. Or
Yes, yes.
63.
Yes, later it was renumbered here, Miller, but.
77.
Yes. In that IA file, this order may be there. 9.
IA7.
9 January.
9 January. Your lordship can kindly come to paragraph 8.
Yes.
By order dated 4th March 2024, passed in WPC so-and-so, the learned single judge had issued an interim direction that the respondent authorities shall receive the bids in pursuance of the NIT dated so-and-so and shall process the same on its own merits. However, the award of work shall not be effected without leave of the court. Well, your lordship will kindly mark this. By order dated 7th of June 2024, passed in so-and-so, the learned single judge had passed an interim order and thereby operation of the Indian corrigendum was dated so-and-so was stayed till the next date. The learned senior counsel for the applicants has been able to prima facie demonstrate that the applicant number 1 otherwise has the eligibility qualifications to participate in the tender process However, clause 5 and 8 of the corrigendum impugned in WPC number so and so, certain additional qualification points were added for supplying in more than one state and for a higher network. The learned senior counsel for the applicants has also been able to prima facie show that the learned single judge in paragraph number 38 of the impugned judgment has arrived at a conclusion that the qualification points at annexure B to the clauses is not rational. The learned senior counsel for the applicants has also been able to demonstrate that although no affidavit in opposition was filed by the state in the proceedings of so and so, in paragraph number 38, the impugned judgment, it has been recorded that on consideration of the materials on records reveals that the respondent authority have explained sufficiently and interpreted the terms without any scope of ambiguity, which is prima facie contrary to records. So, my lord, so far as whatever I have submitted, my lord, the honorable court has recorded this. Matter stands as it is even as on date. And the very crucial fact of the matter is that, my lord, the tender was for a period of 1 year. By now, the period of 1 year is over. And we are still litigating at the court. My humble and respectful submission, very short submission, my lord, is that, my lord, since these are the admitted position, that there was no affidavit filed, that there was no materials placed, and there was an order operating in this state, against this state, my lord, the selection of the respondents, private respondents, are liable to be interfered with. And naturally, my lord, your lordship will ask me that what will be the consequence. Consequence will be that, my lord, they will have to go for a fresh tender. They will have to float a fresh tender. Because even if, my lord, this litigation was not there, otherwise also they would have floated a fresh tender because the period of tender was for 1 year. This is my absolutely, without going into the merit of the matter, my lord, these are the, on bullet points, my lord, these are the 3 points on which, my lord, I submit that the honorable single judge has committed an error in dismissing the writ petition. On the contrary, my lord, the selection of the private respondents as bidders, those deserved interference. My lord, your lordship will kindly see the selection of the private respondents. These are at page number 88. And the sequence of events, my lord, what I have narrated to your lordship, my lord, this is absolutely based on the records. Page 88. Page 87 is the first page, my lord, where, my lord, the respondents' name of the 2 respondents are mentioned: Continental Milkos and Roshina Udyog. Acceptable on the right-hand column, your lordship will find acceptable subject to further lab analysis report of food sample. So their tenders were accepted, and thereafter, my lord, in the process that they did, they rejected our case. Just down below, my lord, our tenders are also reflected. In page 88, your lordship will find Astra Foods Private Limited, which is the appellant in the case. Minimum qualification point so and so could not be secured by the bidder, and therefore it was rejected. My tenders were rejected. Now, therefore, my lord, my submission, this is 24th July. On page 88, your lordship will, down below, your lordship will find the date. That is just below the digital signature, your lordship will find the date. That is 24th July. Now, 7th of June, the honorable court stays the corrigendum. How can you go ahead and make this selection? And interestingly, my lord, you do not even file any affidavit in the matter. Neither on this nor in the other case where, my lord, I amend the writ petition. And in the writ petition, I will just show one paragraph to your lordship. If your lordship will come to page 48. 48, I take a categorical stand that my price, which I had quoted in the tender, that is competitive, more effective.
Yes.
Page 48, your lordship will come to paragraph 18B, last 4 lines.
Yes. This
has been done by ignoring the competitive bid of the applicant and by applying the yardsticks for assessing qualification points which are under challenge in WPC number so and so. Now, this was specifically stated. And this was a categorical statement made on the, this is the after amendment. You do not file any affidavit in the amended writ petition. How, my lord, do you save this election? Very shortly, my lord, without troubling your lordship on the merit. And on the merit also, my lord, the honorable division bench has recorded. The single judge has given a contradictory finding. at paragraph 38, which is at page 192 of the appeal memo, if your lordship will kindly come to page 192. And these are also the points which I highlighted in the written argument. My lord, written argument I have also enclosed in the case. If your lordship will kindly come to page 192, paragraph 38, your lordship will see from the top, on careful comparison. Have your lordship found it?
Yes.
On careful comparison of the above clauses and qualifications at first glance that reflects an irreconcilable item. Now, thereafter, your lordship can skip over 3-4 lines. Thus, it starts from thus qualification points. Thus, qualification points at annexure B to the clauses in the NIT appears not rational. This is the finding of the Honorable Single Judge. But in the very same paragraph, in the next few lines, the Honorable Single Judge says that these are rational, these are not arbitrary. It's an apparent contradiction, which the Honorable Division Bench has also noted in the first order, 9th January order, because Honorable Division Bench has said that since there no affidavits were filed, where is the basis for holding so? So that is my subject to what my learned friend will say. My lord, if he goes on the merit, my lord, then I can also address your lordship on merit. But my humble submission will be that on these points, my lord, the Honorable Single Judge's order may be set aside. The selection of the private respondents may be set aside, and government will be at liberty to go for fresh tender. Otherwise, also, my lord, they would have done so. Had there been no litigation, they would have done so because the NIT was for 1 year only.
1 year is already over.
1 year is already over. Your lordship can see the NIT, my lord, that is at page 61. My lord, that is specifically written in the NIT that it will be for 1 year. Page 61 is the NIT, my lord. And my lord, whatever I have been submitted now, my lord, this is absolutely whatever there is on the record. I have not gone to any case projected by the writ petitioner. It is on the basis of the record. And the orders of the Honorable Court, stay orders of the Honorable Court, my lord, this Honorable Division Bench has already recorded in order dated 9th of January. And based on that, my lord, this stay order was granted to me. That's all, my lord. For the now, my lord, that is the limited submission.
Who is for 1?
My lord, my friend appears for respondent 1.
So number 1.
Yes, madam.
He is the main man, my lord, because state is the entity who has floated the tender.
You are appearing for 1 and 2.
1 and 2.
1 and 2, right, madam.
1 and 2. So what is your reply to his submissions?
My lord, the NIT, my lord, the department called for the NIT, so that greater there could be a participation, madam. So there could be a greater competition, and so that we can select the best of the best winners, madam. Now, in that amendment, my lord, the corrigendum, my lord, the department then inserted 2 more clauses, my lord. And that clauses was prior to my lord, opening of the any bid document, it was given information to all, my lord. So that will not prejudice the petitioner, my lord, because tender was never opened, my lord. Before opening, my lord, the corrigendum was issued. Now, my lord, as per the corrigendum,
But 1 year is already over.
tender period is over, my lord, no doubt about that, my lord. Tender period is over, my lord. Now, my lord, mute question is this survive, my lord. Whether, my lord, the corrigendum is legally sustainable or not, my lord, especially clause 5 and 8, my lord. Now, my lord, the Ladakh Single Judge referred to my lord Jagdish Mandal, my lord. My lord, it is the, my lord, employer who has the authority to put the terms and conditions, my lord. It is not the, my lord, bidders, my lord, who can dictate the, my lord, employer to put the terms and conditions, my lord. So that has been referred, my lord, even, my lord, Cochin International, everything was referred, my lord. So what they are saying, but there is no nexus between the corrigendum and, my lord, the aim to object inserting that corrigendum, my lord. My lord, reason is very simple, my lord, because this is a supply of food grains. So we need such a farm who could, my lord, continue the supply, my lord, even there is a breakup of, my lord, payment, my lord. Because it's a nutritious, my lord, food supply, my lord. It will supply to the children and women, my lord. So that, taking that apprehension, of my lord discontinuation or any my lord shortage of supply, the corrigendum was issued, my lord, without having ill motive or my lord supporting any other of the respondent. Now, my lord, corrigendum seems, my lord, is not arbitrary, my lord. It does not violate the Article 14 of the petition. The reason is simple, my lord, it was inserted or my lord, corrigendum was issued prior to opening of the tender document. So that way, my lord, Article 14 does not violate because that will affect to all the bidders, my lord. There are 4 bidders, my lord, that will make applicable to all the 4 bidders. That will not remain. Now, my lord, as he has rightly pointed out, my lord. Now, my lord,
appeal brief, where the government extended the period by saying that till finalization of the new tender, the old suppliers will continue. And because of that, my lord, I am still continuing with the supply. The private respondents are also still continuing with the supply.
Oh,
Page 59, your lordship will find that order. So the, well, just.
now that's why I say, my lord, how long this interim arrangement will continue?
No, that is
That
for
was
you
the
to
question,
decide. That is for you to decide, but it is not a case that supply has been stopped. Where 2023, 29th May, my lord, that order was passed.
you are still supplying.
I am supplying, all the private respondents are also supplying because the new tender has not been finalized. So my submission, therefore, if they want to make an alternative arrangement, this alternative arrangement can very well continue. But my learned friend has tried to take the honorable court to the merits of the matter, my lord. I have not gone. The reason being that, my lord, otherwise, my lord, on the face of the orders that have been stay orders and the selection, that the way the selection has been made, lord, that is apparently illegal, my lord. If your lordship passes an order today,
He has agreed with you.
yes.
He has agreed with you.
So therefore, my lord, your lordship will kindly interfere with the selection of the private respondents as well as the order of the honorable single judge, because it has to be done. And till the time, my lord, the fresh tender is floated or fresh tender is finalized.
You continue to supply.
Yes, this 29/5/2023 order will continue. That is the my lord, possible solution. My lord, I don't want that I should continue with litigation, my lord. Litigation is not the objective. The state's service has also to be kept in mind. So these are my submissions. So, and on his case, my lord, his case, although similar to mine, my lord, but possibly, my lord,
just a minute. Then, my lord, your lordship has to, my lord, make a ultimate, my lord, observation, my lord, pertaining to that corrigendum, my lord. What will happen to that corrigendum?
no,
Whether that corrigendum will be declared illegal or not, my lord.
No, I am not
Then-
taking the honorable court to the merit of the matter, my lord.
Until
But if my learned friend wants that a decision has to be taken on the merit, my lord, I can answer to your lordship. I can show that how the corrigendum is illegal. But what I felt, my lord, for the purpose of disposal, quick disposal, my lord, that is an aspect, my lord, which is not necessary. But since he is referring, my lord, I can very quickly show how it is illegal and arbitrary, if your lordship allows me.
Go for him, since both sides have agreed on the same proposal. So it will be done like that. Yeah, what Sahiwala says, but what is your submission?
My lord, we account to the, because basically this order has come out
No,
of a.
you are also supplying.
Yes, but no, we are not.
You are not
No,
supplying.
no, I'm not supplying. But if there is a retender, we have no objection.
You are for the private response.
Yes, we participated in the.
No, before that, you were.
I was not
you
a
were
sitting
supplying.
supplier. I was not a sitting supplier.
But you were supplying.
Yes, I am supplying. I am supplying, and the respondents number 2 and 3, sorry, 3 and 4, they were also supplying. 3 and 4 in the read appeal, my lord, they are also supplying.
So Sahiwala is for whom?
He is, my lord, a separate company, my lord. Separate company, he is also challenging the tender. I mean the NIT on the grounds of irrationality.
What is your item number?
5.
Zero six. Oh. You're for Orion Hill.
Yes.
So, The subject matter is same.
Subject matter is same.
Subject matter is same.
Subject matter is
You
same.
also filed the tender.
Yes.
You are not yet selected.
Same subject matter. Well, we participated in the tender, he also participated, and the other two parties also participated. But our tenders have been rejected and theirs have been selected. Now, since my friend is taking your lordship to the corrigendum, my lord, I'll just shortly show to your lordship, my lord, how it is illegal and where the single judge has committed an error. If your lordship will kindly come to page 83.
So this corrigendum is a part of the original NIT.
Original NIT.
So if the original NIT is gone now,
Yes.
after 1 year.
The corrigendum will also.
Automatically goes.
Yes.
Automatically goes.
But his apprehension is that, my lord, if in the new NIT same corrigendum is issued and same. That is an assumptive exercise, my lord. But your lordship can say that since this NIT is now over and the single judge's order is interfered with, they will be at liberty to file. But one thing is this, my lord, this honorable court, on your lordship's brief, my lord, the 7th June order is there. 7th June order, if your lordship will kindly see, that was very specific, my lord. And it was specifically stayed. The corrigendum was stayed by after finding a prima facie case in my favor. If your lord on 7th June order, my lord, there are on the top of your lordship's brief, there in this 3 pages, my lord.
In the IA.
No, on this flag mark, your lordship will find the flag marks on the. Yes.
Oh, yeah.
Yes, this 7th June order.
Oh, yeah.
Last page, second paragraph. Considering the entire submissions. Considering the entire submissions made by the learned counsel for both sides, in the interim, the operation of the impugned corrigendum dated 10th March 2024, so and so is hereby stayed till the next date of listing. Now, this interim order ultimately continues till the final disposal. Question is, my lord, if this stay order was operating, how do you make the selection? You cannot make the selection of any of the parties. So therefore, the selection has to go. And so far as the merit of the corrigendum is said, corrigendum is there, my lord. If your lordship, my lord, permits me, my lord, I can take your lordship to the merit of the submission. If your lordship will kindly come to page 83, what and how they had changed the things, my lord. If your lordship will kindly come to page 83.
Yes.
Page 83, your lordship will find a chart, qualification points.
Yes.
And down below, they require that minimum points have to be secured is 90 points. The scheme that they have given here, my lord, it is almost impossible for anyone, barring the private respondents, my lord, that they will qualify. How? Your lordship will kindly see, they clause 4, they say average turnover should be 10 crores. Now, if I have average turnover of 10 crores, which I have as a bidder, I earn here 5 points. Now, in clause 8, my lord, they say that net worth of a bidder during the last financial year, so and so, as per audited balance sheet, up to 20 crores, 5 points. Up to 25 crores, 10 points. Up to 30 crores, 15 points. And total number of points that have to be secured is 20 points. Now, out of this, my lord, unless somebody secures minimum 10 points, 90 will not be achieved. If your lordship just will add the points, 5 plus 5 plus 5, 3, 15, 20, all the points that have been here, the sum total is 20, sum total is 100. Now, if I am not given 10 points here, I will never be able to score 90. And I will not get 10 because up to 20 crores, they have given 5 points. So this is an arbitrary thing, which the Honorable Single Judge in my respectful submission has overlooked. And the corrigendum that was subsequently floated, my lord, that was 10th January, 10th March. The corrigendum your lordship will find in the next the item number 6, my lord. When I challenge this, my lord, the page 88, when I challenge, my lord, what they did, they suitably changed the conditions.
Page number,
In second,
item number
this-
6.
yes, item number 6, your lordship will find the corrigendum. But there are ways of doing certain things, but surprisingly, my lord, I'm sorry, my lord, I'm sorry, the corrigendum. Just a minute, your lordship, grant me just 1 minute, my lord, I'm coming back to. हाँ? नहीं ये तुम्हारा वाला में है.
One for the corrigendum dated March 2024. After 18.
Yes, that will be at page 88.
Page 18.
Page 88 in the second writ petition, my lord. Item number 6.
I don't know.
Item number 6, page 88, and item number 4, page 80.
Item number 6.
83. That your lord, if your lordship holds it simultaneously, my lord, things will be
In
clear.
item number 5 also there is a corrigendum.
Yes, my lord, these are same. These are same.
Same corrigendum.
Same. Only the pagination will be different, my lord, because briefs are different.
In
But your-
item number 5, it is in page 143.
yes. But in item, your lordship can refer to item number 4 and 6. Now, item number 4, in item number 4, your lordship has seen the page 83. Now, if your lordship will come to page 88 in the item number 6.
Oh, the same corrigendum.
Yes, same corrigendum now. This I had challenged. Here, what they say, clause 4 I have read out to your lordship in page 83. Now, the clause 4 is changed here. Serial number 4 at annexure B, it was average turnover was 10 crore, which they previously prescribed. Now, what they say, this will not be average, this will be annual turnover.
Not less than 10 crore.
Yes, previously it was average turnover not less than 10 crore. Now, this time they make it annual turnover not less than 10 crore. Now, if you make it annual turnover, then what will happen to clause 8? It will remain incompatible with each other. Because previously, clause 8, you said that clause 8 is in tune with clause 4. Now, if you change the clause 4, naturally there will be incompatibility. So, therefore, my lord, this corrigendum also has to go. 10th March 2024 corrigendum also has to go. This is the reason, my lord, the Honorable Court granted me an order of stay. That's all.
We will dispose of the all the 3
Yes,
appeals.
yes.
For the time being, it is judgment is reserved.
Oblige me.
My only solution, my lord, now the other side, my lord, they have said, my lord, the tender period is 1 year. But there is another, my lord, clause which may extend it to another years.
No, that
Right.
is a brief, because the 29th March order I have already shown to your lordship. It is already
That
there.
order says, my lord, interim order is not the final order. Interim order is interim order, my lord.
No, that's why I am explaining to your lordship, my lord, how it is incompatible. Why it is interference is necessary.
Now, that's why I have said, my lord, why, my lord, my only, my lord, intent is, my lord, the food grain should be discontinued. Now they say, my lord, they are continuing, all right, my lord. Now, my lord, when we see the NIT, my lord, basically expandable till 2 years, my lord. Now 1 year is almost left, my lord. Now another one is left, as per that NIT, my lord. No, it's extendable for another 1 year.
That is another thing, but the NIT was for 1 year. NIT was for 1 year.
Not extended till now.
Not extended.
till now. Not
No,
extended
no
till
decision has been taken.
now. My lord. So,
No
my lord,
decision is taken.
my lord, your lordship may kindly give us liberty, my lord. Either we go for, my lord, fresh tender, or, my lord,
It is better you go for fresh tender.
My lord.
Fresh tender.
Well, these things your lordship will kindly interfere with, and they will go for fresh tender.
And you will continue to supply till new.
Till the new thing is
new
final.
customer selected.
Obliged.
In the meantime, my lord,
Next item.
Item 10 can be disposed of, my lord, since matter has been settled. My lord, although the brief is voluminous, issue is very simple, my lord. The private respondents who were the writ petitioners, they were given ad hoc promotion as assistant engineer in the year 2006.
Mr. Ratan,
Yes, my lord.
you will hear it on Saturday, other day, because I have single bench also. There are many other matters.
Yes, my lord. Then this can be fixed on next Monday.
You suggest on this,
My lord, can it be fixed on first? Second of April.
2nd April. After hearing the learned counsels of both sides, the hearing is adjourned to be list on 2nd April for hearing.
Okay.
Yes, sir. Yes. Yes.
My lord, may I mention item number 27, my lord? My lord, there is a my lord, wrong calculations in the number of days of delay, my lord. So, my lord, I may be allowed to, my lord, correct by using fluids, my lord.
You want to withdraw it?
No, my lord, just I want to correct the number of days of delay, my lord.
Oh, sir. You can correct it.
Yes, my lord. Much obliged.
May I please, Lordship?
Hmm.
Lordship, I beg to mention item number 29, Lordship. I have taken consent from the other party.
Hmm.
It may be, Lordship, taken up on next Thursday, Lordship. It's 3rd April, Lordship.
What will be the date?
Lordship,
What will be the date?
3rd.
3rd.
3, I Lordship.
On the request of the learned counsel, Mr. S. Tapin, the hearing is adjourned today. I have also heard Mr. Tapin submits that he has already taken consent from the other side. Is this matter on 3rd April
3rd April, Lordship.
for hearing?
Lordship, obliged.
Please, Your Lordship, I beg to mention item number 11 on behalf of Mr. D. Soki, the counsel for the petitioner.
Item number 11.
Yes, Your Lordship. My Lord, Mr. Soki could not be here today, Your Lordship, because of some personal difficulty.
What is your name?
D. Tamuk, Your Lordship.
The United Counsel, Ms. M.S. D. Tamuk, appearing on behalf of Mr. D. Soki, the United Counsel for the petitioner, prays for an adjournment.
For 3 weeks, Your
Ground
Lordship.
That Mr. Soki is not available today. After hearing the Learned Counsel, have you informed the other side?
Yes, Your Lordship.
The Learned Counsel further suggests that he has already informed the other side. Accordingly, the matter is adjourned today, list after 3 weeks.
Yes, my Lord, there's an interim order, Your Lordship.
The interim order passed will continue until then.
Much obliged, Your Lordship.
May I, Lordship? Lordship, there is one criminal petition. This matter may be fixed for tomorrow because senior counsel is appearing tomorrow.
Joint petition.
Criminal petition 58.
Is it a joint criminal petition?
No, not joint. It's a criminal petition. Joint with IA,
For quashing?
not for quashing. It's for correction of we filed the IA for the correction of this stay order.
Correction of the stay order.
Yes. Order was passed before this honorable court only by you, Lordship.
Okay, tomorrow.
Let's
May I please your lordship?
Yes.
I like to mention unlisted matter, the bail application 2525. This matter already listed in after 10 days, last date on 18/3/2025. But in the last order date, it is very clear that after 10 days, this matter listed and collect the TCR. So TCR already reached in the honorable court. So may I list this matter on tomorrow, Your Honor? Much obliged.
My lord, I beg to mention item number 12.
12.
Yes, my lord. My lord, the conducting counsel, Mr. T. Sunil is having some health difficulties. My lord. Can the matter may be fixed after view, my lord?
Who is absent?
Mr. T. Sunil, conducting counsel. My lord.
Item number
12, my lord.
12. No, his name is not here probably.
My lord.
Akam Sunil.
Yes, my lord.
Acha. The learned counsel MS so-and-so appearing on behalf of Mr. T. Sunil. The learned counsel for the petitioner prays for an adjournment. Have you taken consent for that?
Yes, my lord. Consent taken.
I have also heard the learned counsel, Mr. A. Gamre. Yeah, appearing for the respondent. The matter is adjourned today. When do you want it?
After Bihu, my lord.
List this matter after the ensuing Bihu vacation.
My lord, there is an interim that
The interim order pastoral will continue until then.
May I please, my lord,
Yes.
I'd like to mention item number 28, my lord.
28.
Yes, my lord. My lord, I'm appearing on behalf of S. Side. He's not well, my lord.
28.
Yes, my lord.
What do you want?
My lord, adjournment for 2 weeks, my lord.
After 2 weeks.
Yes, my lord.
You are IBAM.
No, I'm appearing on behalf of A. Sahid.
Okay, Sahid. What is your name?
A. Timu.
The learned counsel, Mr. So-and-so. Appearing on behalf of Mr. A. Shahid, comma, the learned counsel for the review petitioner, prays for an adjournment. The prayer is allowed. When do you want it?
After 2 weeks. Yes, my lord.
Least after 2 weeks. Yes.
Yes, sir. I'm praying my lord, listing upon WPC my lord, tomorrow my lord, for only for withdrawal my lord, liberty.
What is that matter?
Withdrawal only, withdraw liberty my lord,
Withdrawal.
tomorrow.
Hey, Your Lordship.
Yes.
Your Lordship, kindly this matter may be passed over for a while. Your Lordship. Conducting counsel is engaged in other.
Yes.
Lordship, this is a joint petition, Lordship. That dispute is, Lordship, regarding that, Lordship, it is a family matter dispute, Lordship. It
Where
was,
is the FIR?
FIR is a, Lordship, the page number.
Page number?
Page number 42, Lordship. May I read a FIR copy, Lordship?
Yes.
With due respect and humble, I would like to inform you that last night on 21 March 2024 at house name Anil Techi tried to attempt to murder my husband Sri Nilo Techi with a match and local dao. He tried to do it twice, once at 8:40 p.m. and then again at 10 p.m. This was first time he tried to hurt my husband either. It was actually the fourth time. While on a confronting, I get cut on my hand and the damage all the my utensil and cut house by damage. And so, sir, my humble request to you that is kindly action against Lordship. Lordship, regarding that, Lordship, actually the prosecution history is that, Lordship. It was, Lordship, dispute of the land, Lordship, of family matter, Lordship. Regarding that dispute, Lordship,
petitioner number 2 is a complainer lordship. And he is approached to come for the home lordship for the discussion of the property lordship. Exactly boundary where from where ended exactly dispute lordship.
Who is respondent, petitioner number 3?
Petitioner number 3 is also a victim lordship. He is also brother lordship for petitioner number 1 lordship. Petitioner number 1 is a accused lordship. And petitioner
4 is the husband.
husband is a lordship, petitioner number 4 lordship, Nilo Techi lordship.
What do you say, Mr. Ete?
Yes, your lordship, yeah, only section 324, your lordship. It's non-compoundable, your lordship. So, your lordship, since they have entered into an agreement, and that from the agreement, your lordship itself, your lordship, certain conditions are there, and they have been clearly stated that they were relatives, close relatives. So, considering that aspect, your lordship, I will leave it to your lordship.
What it is cost?
Yes.
My lord,
Yes.
this is a joint petition for quashing, my lord, on settlement, my lord. My lord,
Where is the FI?
FIR is at page 19, my lord. FIR dated 8 August 2023, my lord. Case was registered under section 452, house trespass.
Lordship, kindly pass over for a time being, Lordship. Just for time.
They can come.
Okay, after some time. Who will be coming?
Lordship, or G Tado, Lordship. Additional PP. For the time being, Lordship. He is in the Anora court.
Here.
Lordship, this is a joint application, Lordship. In fact, Lordship will find the FIR at page number 24, Lordship. Allegation is of kidnapping, Lordship. Now,
Okay, Mr. Zini, please read the FI.
Lordship,
This is to inform you.
that my daughter, Miss Rupa Chetri, age 14 years, had gone to school yesterday and has not come back to our house. Indira Nagar, 2nd mile, Pasigat, since then. On inquiry, it has been found that Sri Tarjan Sonar of Telam village has kidnapped my daughter, Miss Rupa Chetri, and taken her away and keeping her in his custody at his residence at Telam village. Therefore, kindly initiate action against the culprit Sri Tarjan Sonar and of Telam village and arrest him as per law.
Why they have compromised?
Lordship, in fact, seized the wife, Lordship. She's my wife, Lordship. The alleged accused and the victim, they are husband and wife. And then the informant is the mother-in-law, Lordship. Initially, they were not accepting our relationship, Lordship. So why this FIR was lodged, Lordship. Now they are, in fact, interesting part is, Lordship, they are living together in the same house, Lordship. The mother-in-law is being looked after by the daughter and the son-in-law, Lordship. Father-in-law has died and she is being looked after by daughter and the son-in-law. In fact, Lordship, this is of 2010 case, Lordship. Very old case, Lordship. 15 years old case. 2010, Lordship. 10. Before the judiciary was separated, Lordship, the trial was commenced. Lordship, there are some depositions before at that point of time, Lordship, the judiciary was done by the executive magistrate, Lordship. In that, Lordship, clearly the victim as well as the mother-in-law, who is one of the petitioner here in this case, has clearly stated that out of small misunderstanding, the FIR was filed. That deposition, Lordship, will find it.
Page number?
Page number 57, Lordship. This is the deposition of the victim, Lordship. Lordship, I'm reading it. Whereas I am to state that I owned at the day of 12 October 2010, went with Rohit Vishwakarma, who is the LS accused.
Hmm.
The urgent honor, as per my own consent, as we both loved together. I had appears for the last 2 years prior to go with him on 12/10/2010. And then the deposition of the mother-in-law, Lordship, we find at page 59, Lordship.
Now, who is the petitioner number one?
Petitioner number one is the informant here, Lordship.
Father of the girl.
Mother of the victim, Lordship. Srimati Hema Chetri, Lordship. Rupa Chetri is the victim, Lordship. Petitioner number 3.
She is not 28 years old.
Lordship, Hema Chetri is 52 years. Lordship.
Yeah. No, the girl is not 28 years old. Rupa Chetri.
Lordship, she is of 28 years of age now.
Hage, what do you want to say?
They are in fact having two sons, Lordship. I have annexed the date of birth of the sons also, Lordship.
Lordship,
Yeah, they have 2 sons, Lordship.
So at that
2
time,
children.
she was minor, Lordship, and Lordship, as the Lordship knows that minor consent is equally to no consent in the law fund, Lordship. And Lordship, moreover, Lordship, if they have, Lordship, now married as a Lordship, then there's no document available here that they are married, Lordship. Their certificate is not there or no any document, Lordship. And Lordship, whether call for the LCR, Lordship, at which stage this
But they have stated on oath.
Lordship. During the proceeding also, Lordship, they can apprise the court, Lordship, that they have been living together, then they can be, Lordship, discharged there also, Lordship. Because this is the case, Lordship, 2010, Lordship, at that time.
No, is it a compoundable or non-compoundable?
This is non-compoundable. 363 is not non-compoundable.
Section 363.
Yes,
Lordship.
Lordship, this kidnapping, Lordship, at that point of time, the POXO was not there, because it 2010 matter. So that's why, Lordship, the POXO was not.
Lordship, medical examination.
Regular basis for a period of 2 years. For an amount of 3,65,75,000, my lord. Now, this was a NIT invited by the FCI, my lord, the regional office FCI. Now, since I was eligible, my lord, I, along with 4 other firms, participated, my lord. Thereafter, my lord, in a very flimsy ground, my lord, my technical bid was rejected, my lord, stating that in the bid document, my lord, the name of my firm has been written as TT Enterprise, but it ought to have been TT Enterprises. Just because I did not put S, they rejected, my lord. Thereafter, my lord, I filed a representation, my lord, which my lord will find it. Page 160.
Yes.
Now, this has been written to the Honorable Minister of Consumer Affairs, my lord, that at 14/2/2025, my lord. Now, herein, my lord, I have informed the Honorable Minister that earlier also, under the same manner, I have already got 3 contracts, my lord, and I'm experienced, and it was just a typographical mistake, my lord. Clerical mistake, my lord, because I missed to put out S in the enterprise, my lord. Subsequently, my lord, if my lord turns to page 163, my lord, 163. On the same day, my lord, I took an undertaking, my lord, expressing that TT Enterprises and TT Enterprise are the same firm and one and the same firm, my lord. Owing to this representation, my lord, my bid was allowed, my lord. I was allowed to participate in the technical bid, my lord. Thereafter, my lord, page 164.
But your later headings also say that it is TT Enterprise.
Yes, TT Enterprise and TT Enterprises are same.
Okay.
Yes.
Okay.
Only there we have typographically we did not put S, my lord. They told that verbally they informed us that our bid will be rejected, my lord, in the technical bid, my lord. Thereafter, my lord, 164. My lord, my name is at the last, my lord.
TT Enterprise.
TT Enterprise, my lord. Now, it was opened on 21/1/2025, my lord. Now, out of 5, my lord, 3 qualified, my lord. Serial number 1 and 2 were disqualified in the technical bit.
Yeah, you also qualified.
I also qualified, my lord, because I was allowed to participate, my lord. Day after, my lord, on 21, on the same day, my lord,
Therefore, absence of S, you were not given the work.
no, my lord. Therefore, my lord, after that, my lord, I'm coming to that, my lord. On 21, the financial bid was opened, my lord. Next page, my lord, 165, my lord. I'm at the first, my lord. TT Enterprise, my lord. 165, my lord, page number. Now, my lord will see, I am the lowest bidder, my lord, L1. So, well, I was anticipating, my lord, since I am the lowest bidder, my lord, and my bid was the most responsive of the 3, I was anticipating that the contract would be issued to me, my lord. But in a very shocking and a very arbitrary manner, my lord, on the same day, my lord, in the government e-marketplace, my lord, it's a e-portal, my lord, I came to know that the entire bid has been cancelled, my lord, without assigning any reason, my lord. My lord, we see page 166, my lord. Left side, my lord, cancelled. The entire bid has, the NIT has been cancelled. Left side, my lord. Above 75 days. It has been cancelled, my lord. The entire process has been cancelled, my lord.
The entire
NIT has been cancelled.
the NIT was cancelled.
All the NIT has been cancelled, my lord. Now the process has been completed, my lord. The NIT was slotted, my lord. We participated, my lord. I qualified in the technical bid. I was the L1 in the financial bid. And they cancelled it without any valid reasons, my lord. And now, my lord, thereafter, my lord, I filed a representation, my lord, which is at phase 167, my lord, to the general manager. May I read it, my lord? We would like to submit the report regarding bid number so and so, dated 8/1/2025, name of work so and so. And further, it also informed that earlier our bid was also rejected in technical bid by FCRO Itanagar in same contract, but due to transparency in the GEM portal, we had met representation regarding the same, and then our firm qualified in the technical bid. After qualification in the technical bid, our firm became L1 party in the price bid, and our quote rate is lower than the estimated value of the contract. Now I'm writing this formally requesting a reconsideration of the decision to reject our tender on the ground that the quote price is high.
Okay, what they did now?
Now, thereafter, my lord, to my surprise, my lord,
They
issued a fresh NIT for the same work, my lord. And that too without assigning any reasons, my lord. So I am aggrieved by this the cancellation of the earlier NIT and issuance of this fresh NIT, my lord. It is very arbitrary, my lord. At least they ought to have assigned a reason, a reasonable ground justification has to be done, my lord.
Singh is for 1.
Yeah, I'm for all the FCI respondent, my lord.
Kato is for 1.
My lord. May I submit, my lord?
Yes.
My lord, this NIT dated 8/1/2025 is a regular tender for 2 years between Harmuti, Bandardeva to Corlorian issued by the RO Itanagar, my lord. This is this, my lord, route is for the first time, my lord, the tender was floated, my lord. Otherwise, earlier, my lord, this tender for this route, the tender for this route has been floated for the first time, my lord. Earlier, there was only from Harmuti to Zero, my lord, because the Colorian, the new FSD has been opened by the
Earlier one was from where to where?
my lord, same one, my lord.
Same one.
Harmuti,
Harmuti to?
Harmuti
To Colorian.
Colorian, my lord.
Second one?
Same.
Same, my lord. My lord, this Colorian has been, a new FSD has come up. So this, for the first time, this new tender was issued, my lord. Tender, my lord, tender was cancelled as the rate was too high and was not satisfactory to the FCI, my lord.
Now, my lord, thereafter 21/3/2025, my lord, the impugn NIT, my lord, which has been challenged by my learned friend petitioner. This is an ad hoc tender only for 3 months, my lord. After cancellation of this tender within a week, my lord, by the end of the week, the regular tender, they will be floated, my lord. This tender is for 3 months only for transporting food grains to the remote area to the Coloriang, my lord. Because after three months, my lord, there will be a rainfall, my lord. So that's why, my lord, this ad hoc tender has been issued for meeting
why the
meeting the
earlier-
exigency, my lord.
Earlier NIT was were cancelled.
My lord, I am coming, my lord, to that effect. Because, my lord, this rate is, my lord, too high, my lord, and it has been floated for the first time, my lord. My lord, this as per the contract manual, my lord. Contract manual of the Food Corporation of India, my lord. The last page, my lord, may kindly be taken.
Last page.
Last page, my lord.
Yes.
4.4 clause, my lord. Reasonability of tendered rates, my lord. Reasonability of the tender rates should be examined in a transparent way after observing relevant GFR. GFR, my lord, meaning is general finance rules, my lord. After observing the relevant GFR guidelines and FCI instructions issued from time to time with the proper documentation reference before acceptance, rejection of any tender rate. While examining the reasonability of the offered rate, comparison of rates should be done in the absolute terms of the rate with nearby other existing FCI, CWC, SWC, other PSUs discover tender rate and prevailing market rates for similar services. Prevailing market rates to be obtained just prior to the opening of the technical bid, my lord. So, my lord, the reasonability has to be seen before accepting the tender. My lord, one audit report of the FCI, my lord. Yes. In a similar circumstances, my lord, one NIT was accepted by the FCI, and there was a vigilance, my lord, audit report, my lord. This is the transaction audit report for the entire Arunachal Pradesh. At second page, my lord, point number 5, irregularities in the process of awarding RTC contract FSD Valkum to FSD Tawang. Now, my lord, may come to the last, second last page. Down below is marked as page number 11. Second last page, my lord.
Yes.
Point number 3, L1 rate. May I read it, my lord?
Yes, yes.
L1 rate awarded at the higher than 19.5% of the previous contract in the first attempt. My lord. Here also, this is the first attempt. The previous rate of the regular contract was rupees 2,800 per metric ton, and the L1 rate for the awarded contract was rupees 3,346 per metric ton. Thus, the accepted rate of the contract was 19.5% higher than the previous contract. No attempt was made by the management to go for the second attempt so that the lower rate could be obtained, my lord. So, my lord, here in this case, my lord, since it is for the first time and the rate was high, my lord, the rate which quoted by the petitioner was 19.5%, my lord. So, my lord,
My lord, in fact,
I have not completed. FCI authority, my lord, in their notes, it have made a comparison with the other FSD, with the other routes, my lord, and it is found that 19.5% is too high, my lord. Whereas in the other route, it is 16.5, or I brought the comparison chart also, my lord.
No, in the NIT, was there any fixed value of the work?
Estimated value was there.
yes, yes, ma'am.
It is always that the tender report below the estimated rate. Even then, it was mild high, my lord.
In my
So, my lord,
calculation,
the my petitioner has challenged the ad hoc because because, my lord, the regular tender is coming up, my lord. By the end of this week, my lord, regular tender will come, my lord. So, I rely on one decision of the Honorable Supreme Court, NG projects, my lord. May I just? I'm relying on para 23, my lord. reported in 2022 6 SSC 127.
Para number 22.
Para number 23, my lord, last page. May I read it?
Yes.
In view of above judgment of this court, the read court should refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of the tenderer. The court does not have the expertise to examine the terms and conditions of the present day economic activities of the state, and this limitation should be kept in view. Courts should be even more reluctant in interfering the contracts involving technical issues, as there is a requirement of necessary expertise to adjudicate upon the issues. The approach of the court should be not to find fault with magnifying glass in the hands. Rather, the court should examine as to whether the decision-making process is attempt after complying with the procedure contemplated by the tender conditions. If the court finds that there is a total arbitrariness or that the tender has been granted in malafide manner, still the court should refrain from interfering in the grant of tender, but instead relegate the parties to seek damages for the wrongful exclusion rather than to injunct the execution of the contract, my lord. So, my lord, my humble submission is that there is no malafidiness, no arbitrariness, because the rate was high. The FCI has full authority to cancel the tender and go for the retender, my lord. And we have not barred the petitioner, but petitioner can participate in ad hoc contract also, as well as in the regular contract, which is coming up, my lord. He may, if he may agree, my lord, he may at best can take the damages, my lord. Or meanwhile, we will file our affidavit in opposition, bring all the record, my lord, the office note.
Whether you file an affidavit in opposition.
My lord, only 2 or 3
My lord,
points.
this is only an ad hoc, my lord, that it should not be stayed by the, otherwise PDS system will be hampered, my lord.
Now, my lord,
And this is a, my lord, FCI is run by public exchequer, my lord. It's a public money involved, my lord.
Done. Done.
Yes.
My lord, I'll just reply to what my lunchman has said, my lord. Now, he says it is 19 point higher than the estimated cost, my lord. But I say, my lord, my quote, which I've, my rate which I quoted is, in my calculation, it's 11 point below the estimated cost, my lord. Because estimated cost is, my lord.
So wait till they file the counter affidavit.
My lord, now, since the fresh tender, it is the last date is on 28, my lord. Now, when they will file an affidavit, 28, and if
So this
they-
is an ad hoc tender. my
Please,
lord.
now I'm speaking. Yes. When they start with the, they go ahead with the tender, then where will I go, my lord? Now they say that my tender is higher, my lord, but in fact, my tender is lower, 11 point lower than estimate cost, my lord. And my lord, they said, my lord, only a simple thing, my lord. They said that they have compared the rate with the other FCIs, my lord. My lord, the rate which has been quoted for Tama and Bomdila or from Bandara to Koloriang cannot be compared with the FCI godams from Pasigat, from Bandara to Pasigat, my lord, or from Pasigat to Namsai, my lord, because the roads are different, my lord. Because and before floating the tender, my lord, they have already prepared a DPR, my lord. This DPR has been prepared by the FCI, my lord. They have seen all the conditions, my lord, the rates, the road conditions, and how much it will take, my lord. They have calculated everything, my lord. Now they say, since they've compared, they cannot compare, my lord. This is an independent tender, my lord. The conditions from Bandara to Kolorang would be different from the conditions or the rate from Bandara to Pasigat, my lord. Because it's a plain area, but it's a hilly area, my lord. Now, I have already quoted my rate, my lord. It's below, and they say it's higher, my lord. Therefore, and then, my lord, they have not assigned any reasons, my lord.
You have to wait for some time.
May I humbly pray till the returnable date, my lord. May I humbly pray, my lord. Otherwise, I'll be highly prejudiced, my lord. My lord will kindly appreciate that, my lord. The last date for the tender, my lord, is on 28, my lord. And the moment I participate in the tender, my lord, the case becomes infructuous, my lord. My lord is well aware of that, my lord.
Heard Mr.
Only till that, my lord.
If for the petitioner, heard Mr. M. Katu Diladit, Deputy Solicitor General of India. If for respondent number 1, heard Mr. B.K. Singh.
For respondent number 2 to my note, 6, my lord.
2 to 6. Issue notice, no formal notice is required to be sent. That's because Mr. Katu and Mr. Singh have accepted notice. Heard the learned counsels of both sides in the matter of a prayer for an interim order. Para. Mr. Singh has relied upon, to that effect, Mr. Singh has relied upon a judgment of the Supreme Court that was delivered in Messrs. NG Projects Limited versus Messrs. Vinod Kumar Jain and others. Reported in 2022.
6 SCC.
127. Paragraph 23 of the said judgment is quoted as under. After considering the submissions made by the learned counsels of both sides, it is hereby directed that the prayer for interim order shall be considered after filing of the counter affidavit by the respondents.
Now, my lord, if they file a counter affidavit after 28, my lord, I will be prejudiced, my lord.
Short date may be given 10 days.
Today is 25, my lord, 3 days, my lord. And I cannot even participate in a tender now, my lord, because once I participate, my lord, I give in, my lord. Only,
You are late in coming to the court.
my lord,
You are late in coming to the court.
no, my lord, it was issued on 21, my lord. The fresh tender has been issued on 21, my lord. Today is 25th.
Okay, you have to wait.
My lord, I will be highly prejudiced, my
Under
lord.
the given cir-
Only till returnable, a short date may be given out, only till returnable date, my lord.
No.
Only till returnable date, my lord.
On 7th, my lord.
And also, till then, my lord.
Place this matter on 7th April.
Till then, because on 28 it will be open, my lord. The last date of tender is on 28, my lord.
Honestly speaking,
Yes, my lord.
I do not find a merit in your petition also. That is why.
No, because, my lord, they have to assign a reason, my lord. Because, see, I'm a,
7th April. Let us see what happens. You wait,
Obliged, ma'am.
then. Number 7.
It is Lordship. Lordship, I'm running from pillar to post to get my bills to be cleared. Lordship, I'm asking for a bills to be cleared. The fund has been received by the department in the month of February, 3rd of February, in fact. So since then, I'm running pillar to post to get my bills to be cleared. Lordship, kindly come to straight away the order of the finance department.
Tapin is appearing for 1, 2, 3.
After
Four.
6, after 6.
All of them. For all.
All. Lordship, I need to take instruction in this case, Lordship. Okay, the matter will be fixed on Friday or Monday.
Monday is Monday, not next month.
Yes.
1st April or 2nd April? 2nd April.
Lordship,
1st April.
Lordship, there is a glitch here. If you kindly see the order of the finance department, the fund will be lapsed. It will go back.
You have to wait. Let him take the instructions.
Friday, Lordship. That will do.
Heard Mr. K. Saxena, appearing for the petition. Heard Mr. S. Tapin, the learned senior government advocate. Appearing for all the respondents. Mr. Tapin submits that he needs to take instructions and therefore pray for some time. After hearing both sides, his prayer is allowed. Least on 1st April.
Lordship, in that case, it will become lapse.
You wait till 1st April.
Obliged.
I remember it.
Yes, I will. Well, this issue, my lord, pertaining to land acquisition, my lord, for construction of my lord, frontier highway, my lord. Now, what happened in this case, my lord? Issue frontier highway, this is 3-part, my lord. Lata to Sarli, Sarli to Huri, and Huria to Talia, my lord. Now, my lord, know that, my lord, before, my lord, this resettlement act, my lord, 2013, my lord, the land acquisition, my lord, was
You have not yet received the compensation.
no compensation. No, my lord, we are not. They are preparing the compensation, my lord. We are not on what they are doing, my lord. My lord, no, this frontier, my lord, means, my lord, we are yet to get the facility of all weather road, my lord. We are not against this road construction, my lord. We are not against compensation, my lord. But we are in the process, my lord. How they are doing, my lord? Instead of visiting the ground survey, doing ground survey, my lord. That is the mandate of law, my lord. They are preparing those compensation, my lord, without our knowledge, my lord, in the closed room, my lord. Therefore, my lord, my humble fear in this case only is to, my lord, direct them to, my lord, prepare this compensation, my lord, by ground survey, or in the ground, my lord. Just I will not burden, my lord, with so many things, my lord. This motion stage, my lord. I will indicate just 2-3 things, my lord. 2-3 pages, my lord. My lord will currently have a look at page number 78, my lord. My lord, no, my lord, before this, my lord, the land compensation, simply known as Land Compensation Act 1994, my lord. Now, resettlement, my lord, will right, new act, my lord, 2013 is known as, my lord, right to peer compensation and transparency, my lord. In the process, there should be transparency, my lord. Therefore, page 78, my lord, will have at para 7, my lord. The district administration, after publication of the circular, shall conduct a joint survey. This is the joint survey, my lord, of the site along with the requiring body and the affected people, my lord. Villager community, whoever the project is affected by constituting a board of officers, my lord, of concerned district SOD under the chairmanship of deputy commissioner. The concerned landowner, my lord, shall be educated about the mode of acquisition of the land as such its rate prevailing as on the date in the district. The detailed list of rate of land asset for acquisition have been enclosed, my lord. Now, I am reading, my lord, this is a part of, my lord, manual for land acquisition by our state, my lord. This is in consolidation in the Land Acquisition Act, my lord. Normally, my lord, land acquisition, my lord, itself categorically hold those process, my lord. But to simplify the process, my lord, this manual, my lord, has been laid down by our state, my lord. Now, next page, my lord, you kindly see, I invite my lord attention at page number 95, my lord. This is the foreign, my lord. Even the annexure has been given, my lord. Page number 95, my lord. My lord, have a kindly look at 95, my lord. This is annexure 7 part of this manual, my lord. Now, this is the top of the heading, my lord. We'll see ground survey report, my lord. This is there should be ground survey, my lord. Thereafter, there should be signature of the owner, my lord. Down below, my lord, we'll see, my lord, signature of the land owner. And there should be a signature from all the board member, my lord. Down below, my lord, ADO member. Those should be the signatory, my lord, in the any report, my lord, prepared by the for compensation, my lord. This is the mandate of law, my lord. Mandate of law, my lord. Now, page number 100, my lord, we see, my lord. For time being, my 100, my lord. 100, my lord. Third para, 100, my lord. 100, second para, I am reading, my lord. To facilitate question of the above requirement, public hearing was conducted, my lord, on that hearing place, a notice was served upon printer of the right to, this is, my lord, Lara Act, my lord, that all persons have interest in said land to appear personally or by agent or advocate before the collector on and to the state, writing and signed by the party, my lord. This is the mandate of the law. This permit had been prescribed, my lord. Now, in my case, what they did, my lord, the compensation, my lord, was prepared without ground survey, my lord, without our knowledge, my lord. That was sent for approval, my lord. Luckily, my lord, you kindly see at page number 54, my lord. 54, my lord. This is the last page I'm indicating, my lord. Luckily, my lord, the district authority, my lord, without our knowledge, my lord, prepare the land compensation, my lord, and prepare my page number 57, my lord, or 54, my lord, to the director, my lord. Page number 54, my lord. 54, my lord. May I read this, my lord? 54, my lord. 54, my lord. 54, I am reading. To the Deputy Commissioner, Kurungkum District Collector, regarding a draft post estimate against acquisition of land for the construction of proper highway, frontier highway road. This is wholly to Talia, my lord. Such and such. Madam, my lord, subject. Or madam, with reference to your letter on subject cited above, I am directed to inform you that there are some observations on the draft post estimate as mentioned below. No consent letter from the requiring agency has been enclosed, my lord. My lord will kindly note this, my lord. The rate or forest item are taken in quantity without giving any detail of the number of the tree and size of a timber in a diameter, my lord. Now, I humbly believe, my lord, to measure a diameter of tree, my lord, the ground survey is very much necessary, my lord. In a closed room, my lord, I cannot measure the tree which is not in front of me, my lord. Further rate timber are observed to be not as per the manual 2029. Density of plantation is also not found admissible. Rate of some structure are not as per manual 2022. The rate of ornament trees are not as per manual 23. PEEP, my lord, will kindly note, my lord. The constituted board has not signed consolidated compensation estimate, my lord. My lord, I have indicated, my lord, this is the mandate of the law, my lord. All the board need to sign, my lord. Therefore, today, my lord, my humble submission, my lord. My lord has seen, my lord, ground survey, my lord. Signing of board is the main, presence of owner is maintained, my lord. I am today not saying, I am not paying any interim debt, restrain them to calculate the compensation, my lord. I am simply praying, my lord. My interim prayer is, my lord will pass an order saying, my lord, without, my lord, they will not prepare and finalize this draft estimate cost without without board member and without ground survey, my lord. Ground survey is mandatory, my lord. Without a ground survey, how can they prepare a compensation, my lord?
Okay.
Only that's prayer I'm making, my lord.
My lord, I appear for 1 to 5. My lord, developmental work should not be stopped.
No, but I'm
This
not.
ground survey and this
I'm not saying, my lord, that should be.
they can carry out ground survey, but the developmental work, this is only for preparing the estimate.
You are for 1 to 5.
1 to 5.
Third, Mr. L. Parmi, appearing for the petitioners. Third, Mr. N. Newton, additional advocate general. Appearing for the respondents 1 to 5. Issue notice, no formal notice is required to be sent to the respondents 1 to 5. That's because Mr. Oton has accepted notice. Extra copy of the petition shall be provided to him. The petitioner shall take steps for service of notice upon the respondent number 2, respondent number 6.
6, my lord.
By registered post TV. The prayer for an interim order shall be considered after finding of the counter affidavit by all the respondents. List after 4 weeks.
My lord, I have made a category statement here, my lord. If my lord allow me to, I have made a category statement. What did you, after this, the my lord seen the letter of the director, my lord. After letter from the director, my lord, they repeatedly, my lord, I have approached all the authority, my lord. My lord, that indicate at least all the page contain the whole my representation, my lord.
Let them appear.
I'm simply praying, my lord. I'm not saying development activity. I'm simply praying, my lord. Let the compensation list be prepared by only ground ground visit, my lord, by ground report, my lord, ground survey, my lord. That only, my lord. I'm not saying not that I'm not praying, my lord, to restrain them from preparing the estimate cost. I am praying
that process is already going on. They will pay you the
no, that's why, my lord. They are not. No, my lord. They are not. I have my category is statement, my lord. See, my lord. It not today, my lord. Since, my lord, after direction by this direction, my lord, ground survey is direction of ground survey is by own their additional secretary, my lord, director lane management, my lord. Even then, my lord, district authority, my lord, are not visiting the ground, my lord. I am simply saying, let them prepare the compensation by ground survey, my lord. Only, my lord, will kindly let the compensation prepare but ground survey. That only 8, my lord.
Wait for some time. Wait for some time. Let them file the counter affidavit. After that,
my lord, then it's, my lord,
your prayer will be considered.
Status quo, my lord. Status quo.
No interim order now. After filing of the counter affidavit, your prayer will be considered.
my lord, sorry, my lord, my lord, will kindly note, my lord, this is a case, my lord, wherein, my lord, the villager, my lord, or are from, my lord, frontier area, my lord, they are yet to get, receive those road facility, my lord. In such taking advantage of those, my lord, I'm humbly praying, my lord, I'm not saying, my lord, this development activity is stay, my lord. I'm not saying, my lord, we are against no construction of road, my lord. And we are not against preparation of the compensation also, my lord. My humble, my lord, minimum prayer only is, my lord, at least, my lord, if someone is my preparing, acting on my lane, my lord, at least I need to know, my lord, how much of lane, my lord, how much of property is being taken, my lord. That at least in my presence, my lord, for my presence in the ground service necessary, my lord. So therefore, my lord, same, I am only ground survey, my lord.
Wait for some time. Let them appear first. After that. Okay, next question.
Oh, yes, my lord.
Tado has come.
My lord,
G Tado.
yes, my lord, he's there. My lord, FIR is at 19, my lord. It is a joint petition, my lord. By this FIR, my lord, the case was registered under section 19, my lord.
Okay, please read the FIR.
Yes, my lord. My lord, FIR against Gora Taming Choncho, my lord.
You start from start.
My lord, as referred above, it is to inform you that on 14/7/2023, around Shonsho, one Sri Gora Taming, this is respond number 2, petition number 2, came to my residence at D sector, started disturbing me and asked me to live peaceful. He violently hit me with shovel in my head and deteriorated my left ear without any valid reason. On 22 July 2000, around Shonsho, Sri Gora Taming trespassing my residence, determined breaking my gate partition wall of my residence. Following next morning, Sri Gora Taming warned to park his car inside the house premises, claiming my wife's lands and denying to leave. Also threatened us to dire consequence and keep surveillance over my wife, looking for opportunity with malicious intention. Furthermore, Sri Gora Taming Shonsho, 2 August 2020, around 1 and completely dismantled my gate, trespassing yet again. It started situation thus, considering my plight and habitual and recurrent attack, I have approached you, kindly take cognizance of the first Shonsho. But this is the FR. These two petition number 1 and 2, they are family relatives, Malo. The petitioner number 1 is the brother-in-law.
Just a minute.
And
who is the informant?
Informant is, my lord, the petitioner
Gurang?
number 1, my lord.
And Gurang?
And 2 is, my lord, alleged accused, my lord. They are in a family relatives, my lord.
Gora Taming.
Yes, my lord. And this petition number 1 is the brother-in-law of the petition number 2. My lord, based on this, my lord.
No, who is the brother-in-law?
Brother-in-law is, my lord, petition number 1.
Petitioner number 1 is the brother-in-law.
Yes, my lord. He married to the sister of petition number 2.
Oh, okay.
My lord, this, as per this FIR, all section is compoundable. And subsequently at page 21, my lord, having investigated, the IO has submitted charge sheet, same section, but that's all compoundable. But subsequently, my lord, at page 21, subsequently, my lord, after submission of the charge sheet, the learned trial court has considered the CC, and while considering this consideration of charges, the learned trial court has framed the accused person under section 326, my lord.
Where is the order?
At page, my lord, 36, my lord, page 36, and relevant next page 37, my lord.
Oh.
326, my lord. Now, 326 non-compoundable, my lord. After this, my lord, after the CC, my lord, the party, my lord, both they enter into, they have compromised, they have settled the matter at page 38, my lord.
Okay,
Only this is.
Tadu, what do you want to say?
Here is a grievous injury.
That is why 26, my lord, recently, January recently, my lord, January, even the conviction under 226, my lord, 326, that same section, my lord. After conviction, Honorable Supreme Court allowed the settlement, my lord. Page, my lord, you see it, page, para 4, 5, my lord. Basing on, even after conviction, my lord. Even after conviction, against the conviction, went on appeal on merit, but they could not succeed. But later on, they come up with the settlement, madam. Considering this settlement, madam.
This was under section 326.
Yes, madam, 320, madam, page 20, para 4 will see, madam. It was decided on 7 January 2025, para 4, madam. 326, madam, same section. Para 4 and para 5, in light of amicable settlement, madam. This after family relatives, my lord. It's not offense at large, public offense, but it's an individual, my lord. Para 4 and 5.
Otherwise, there is no denial of fact that the incident was took place on that very day, very night. So, grievous injury, if parties agree to
nothing remains, my lord.
Compromise with another, then I leave it to this court.
Okay, this cost.
My lord, deeply.
My lordship, leading counsel here in VP Cha has left due to some urgency, personal urgency, your lordship. So matter may be fixed on 2, your lordship, on
VP Cha.
VP Cha, your lordship.
It will be taken up next week.
Next week on 3, your lordship, yes. 3.
On 3.
May 3, yes, your lordship.
After hearing the learned counsels of both, so you want to say?
Your
something?
lordship, on 3, I will have something. I come from Pasigan.
Then you suggest on date?
Premiums 9 or 10.
9 or 10?
Yes, no, sure.
9?
9.
After hearing the learned counsels of both sides, the matter is adjourned today. List on 9th April.
Obliged, your lordship.
May I please, my lord.
Yes.
My lord, in this case, I have a very limited prayer, my lord. I'm challenging the judgment and sentence order dated 27/8/2024, wherein I've been convicted under section 20B to C of the NDPS Act. And now, my lord, this is only for the consideration of IA. My lord, I'll only read 2 pages, my lord, and I'll try to convince my lord that there's a clear violation of the mandatory provision of section 42(1) and 42(2), my lord, which in fact vitiates the whole trial proceeding, my lord. I'll just take my lord, firstly.
How many days he is in jail?
Now, since my lord, since
How much was the
7
sentence?
months, my lord.
7 months. And how much was the sentence?
The sentence was arrived for 10 years, my lord.
8 years.
10 years, 10 years.
10 years.
I also have a very good ground, my lord. I can show that from 2 pages, my lord, I can show that there's a clear violation of section 42, which is mandatory, my lord.
But it is too early.
My lord, but
Only 7 months.
But my lord, there's a clear case, my lord, violation of 42, in fact, which vitiates the whole proceeding, my lord.
Not on the 40 case way.
If my lord, if I take my lord to only 2 pages, my lord, I won't take much time, my lord. And 1 authority, my lord. That's it.
Yes. In the judgment.
My lord, yes, my lord.
Paragraph?
Firstly, if I may take my lord to page number 152, my lord. That's the FIR, my lord.
152.
152, my lord.
This is the FIR.
Yes, my lord, if I may read, my lord. It is to inform you that as per input received from intelligence branch, a special MCP was conducted by 61st BN SSB A Company Samphung at near BOP Samphung on Oxford Road on 2/9/2021 from 22:30 hours to 23:30 hours. My lord, may kindly note this, 22:30 hours to 23:30 hours, which is in the midnight, 10:30 to 11:30, my lord.
under the commandership of myself, ASI GD, Labor Chand Arya, along with 7 others SSP personnel. Now, my lord, I'll skip this part. And if I may take my lord to page number 188, the deposition of the informant. 188. 188, my lord.
Yes.
May I read? I cannot remember the appearance of the accused person standing on the dock. On 2/9/2021, there was Naka near Orange Garden at Samphung area. I have received information that some vehicle was coming from downside and I was called by company headquarters. During that time, one vehicle was coming from downside in the speed and we have prepared barricade to stop the vehicle, but the vehicle was fleeing away backward. We have apprehended the vehicle and opening the dicky, we have found some plastic packets containing suspected cannabis. We have handed over the driver of the vehicle along with the vehicle and contraband substance at Kalakang PS on 3/9/2021. During the operation, I was leading the group consisting of other person. I have prepared seizure memo regarding recovery of contraband substance and filed written FIR at Kalakang. The next page, madam. Cross-examination by the defense, madam. It is a fact that I have received the information on 2/9/2021 and FIR was filed on 3/9/2021. During apprehension until presentation of the seized material at police station, I have not mentioned about the custody of same money. It is a fact that I have not measured the contraband substance and mentioned it 40 kg on assumption. It is a fact that I have not exhibited the seized material and samples collected by me. It is a fact that I have not prepared any memo of handing and taking of seized material and accused was at PS. It is a fact that I have not drafted the FIR. Now, from perusal of the FIR and the deposition, my lord, it is very apparent that the seizure was done at the midnight, my lord. At 11, from 10:30 to 11:30, my lord.
Where is the FIR?
FIR, my lord, page 152. 152, my lord. In the top, it has been written, my lord. 152, my lord. It is to inform you that as per
This is PW1.
yes, my lord.
He is the informant.
Informant, my lord. Now, if I just read 3 lines of the FIR. my lord.
Okay, all right. Mr. Tadu, what do you want to say? You want to say something?
Yes, your lordship, prosecution has examined as many as 13 witnesses in this case. There are 6 personnel in Naka check gate.
Notice was issued to whom?
Notice was issued to the prosecution, my lord, to the PP, since the impleading of the party is not mandatory in a case of an appeal under NDPS Act.
Okay, all right. Heard in the I heard Mr. J. Sering appearing for the petitioner. Heard Mr. G. Tadu, the learned traditional public prosecutor for the state of Assam. Para. This is an application under section 430 within bracket 1 of the BNSS 2023, praying for suspension of sentence as well as for releasing the applicant on bail. Para. The convict Sri Tanjin Sering was convicted and sentenced on 27/08/2024 by the learned special judge NDPS Bomdila in NDPS case number 13 of 2023. He was convicted under section 20 within bracket small b within bracket Roman 2 within bracket capital C of the NDPS Act. And he was sentenced to undergo rigorous imprisonment of 10 years. Fair. I have considered the submissions made by the learned counsels of both sides. I have also gone through the FIR and the evidence of the informant. I have considered the judgment, impugned judgment. Fair. The para. It is hereby directed that till disposal of the connected appeal, the sentence imposed upon the applicant, Tanjing Sering, on 27/08/2024 by the learned special judge NDPS Bomdila
in NDPS case number 13 of 2023 shall remain suspended till disposal of the connected appeal. Para. The applicant, Sri Tenzing Sering, is allowed to go on bail of rupees 25,000 rupees, surety of like amount. With the satisfaction of the Lord Special Judge NDPS Bomdila. The I stand disposal.
Deeply, deeply on. In the main appeal, my lord,
In the appeal,
let there be a direction to prepare a paper book, my lord.
heard Mr. J. Sering, appearing for the appellant, heard Mr. G. Tadu, the learned additional public prosecutor for the state of Arunachal Pradesh. Registry is directed to prepare the paper book. After preparation of the paper book, this appeal shall be listed for hearing.
Deeply on.
May please, your lordship. This is a petition for quashing of the FIR and subsequent proceeding, lordship.
Okay, where is the FIR? Show me the FIR.
FIR is page at lordship type copy at page 34.
34.
Yes. Lordship, just brief take of the case. Just I've given here in the.
No, just a minute. Let me go to the FIR first.
Yes.
Now they have compromised.
Yes, lordship, already compromised. And petitioners are all are accused as well as all the victims are petitioner. In this year, lordship, all the three accused as well as the victims who are injured, they are coming up as a petitioner here, lordship, jointly. And in the FIR, it seems to be very serious matter, but there is of course, there is a pushing and pulling, and medical report is page 46, lordship. Kindly see just bruise and 46.
Only bruises.
Yes. This is the doctor's.
Simple injury.
Yes, simple injury. Then next page, lordship. Also bruise. This is the only lordship. There is some misunderstanding between the party because on that incident day, the one of the friends of this accused made a motorcycle accident, and he was admitted in the community health center, but doctor has referred to the district hospital, which is far away from the hospital. Then there is no any vehicle to transport, evacuate there. So ambulance was parking in the garage, and accused has approached there. The driver kindly give the because we don't have any vehicle. But driver said that this is a defective. Such a brand new vehicle, how can be So because of that, there is a pushing and pulling started. And
Okay,
this is the
Hage, what
case
do you
of-
want to say?
Lordship, all the sections are private in nature, Lordship. Only the PPF Act is public
That is not
property.
compounded.
Yes, sir. But Lordship, if it is not prima facie, it's not well established, then it can be passed, Lordship. If all the persons are there mutually settled,
Yes.
Lordship.
Okay, it is passed. Obliged.
Right.
Yes.
Item number 13 is for final hearing because the paper book is ready. So Lordship kindly take it at 2:15, Lordship, I shall be highly ordered.
I will not take the criminal appeal today for hearing matters because it will become CAV for a long time. I have already collected the CAVs here. So I don't want to engage my.
He had the bar for 22 months, Lordship, and his mother is very sick. So
And
Lordship
you-
may
you-
kindly only take up the
you
IA, I
take-
shall be
you-
highly obliged, Lordship. Only the IA part.
Under what section he was convicted?
NDPS
22 B2C, Lordship. 10 years imprisonment, Lordship.
You take it in the next week.
Next.
You suggest one date for you will have to come here.
In that case, Lordship, I will have to see for a date. So Lordship, kindly take up the IA, Lordship, I shall be highly obliged. I will wait for my turn, Lordship, no need to take it at 2:15.
I have other matters also. So that is why I don't want to take it now.
If your Lordship kindly take up the IA, Lordship, I shall be highly obliged.
I will not take the I also. You suggest one date, you come again, you have to come.
Lordship.
In the month of April, you come. First week.
First week. Yes, sir. We'll Lordship take some instruction, Lordship. We'll
Okay.
submit it after some time, Lordship.
Okay, now I will dictate the order now, you give the date to her.
Lordship.
After hearing the learned counsels of both sides, the hearing is adjourned today. List on gap for hearing. He will give you the date.
Lordship. Keep going.
Okay.
Matter pertaining to principal seat, BA application number 771 of 2025.
My lord. Yes. Is it a second application?
May I please, your lordship.
No, is it a second application?
My lord, item number 1 and 2, my lord, arising out of the same FIR, my lord. In item number 2, my lord, case there was earlier called for, my lord. And my lord, earlier your lordship has rejected, my lord. Once, my lord. Now, my lord, today is, my lord, 86 days today, my lord. And other co-accused also, my lord, granted bail, my lord.
What is the maximum?
I have
period?
annexed the your lordship's order and also
No,
the
what is
co-accused
what
order,
is
my
the
lord.
maximum period? Is it a 60 days offense?
Your lordship's order, my lord. Earlier reject order, your lordship's order pays 19, my lord.
No, is it a 60-day offense?
Am I audible, my lord?
You are audible, but probably I am not audible. Have you
Yes,
heard
my
me? Is it a 60-day
apologies.
offense?
Very
low sound, my lord. Low sound. Huh?
No.
Sound, low sound. Sound to wide. Oh, microphone to below. Sound is low.
Yes, my lord. My lord, today, my lord, now, my lord, 86 days, my lord. And item number 2, my
86
lord,
days.
case there. 86 days, my lord.
Yeah, how much? 56.
86, my lord.
86.
86, my lord.
Only
86, my
4
lord.
days left. Huh?
4 days left.
Only
my
4
lord.
days left.
Yes, my lord. 4 days left, my lord.
Wait.
Your Lordship's earlier order, page 19, my lord, and co-accused order also I have annexed, my lord. From page 15 onwards.
Charge sheet filed on Mr. Sharma, you take instructions.
My lord, I can, my lord, today my lord not file, but my lord, this subsequently progress, my lord, may file in 2 or 3 days, my lord.
CD is here, my lord, with them.
CD is here, my lord, one copy CD is, as you can see.
All the persons, my lord, allowed to go on bail, my lord, all.
My lord, one thing, my submission is that, my lord, as it is, my lord, rejected by your lordship, it is a second petition, my lord. What is the new ground, my lord?
Second petition also considered, my lord. I have annexed some orders, my
But
lord.
a new ground
That
may should be.
Amir Ali also, my lord, earlier rejected, my lord, second time considered, page 15, my lord. I have annexed the order, my lord. Second application, my lord, that's what considered, my lord. And one is Chan Mahmud is also one there earlier rejected along with my bail application, my lord. He was also granted bail, my lord, Chan Mahmud, my lord. That order page 17, my lord, bail order. Subsequently, my second bail order, my lord. Earlier reject order is page 19, Chan Mahmud. Along with my bail application, it was rejected. And my lord, it is there, my lord, only 4 days left.
The second bail application is of the same FIR.
Same FIR, my lord.
So, Mr. Munir is there.
My lord.
Mr. Munir is there. It is also a.
Lordship, on for item number 2, Lordship.
How many days he is in custody?
Lordship will kindly see the petition, Lordship. There are 2 petitioner, Lordship. For petitioner number 1, Jairul Haq, Lordship, he is for 86 days.
Yes. The second one?
Lordship, and this Jairul Haq was once rejected by your Lordship. And the second one, Rustom Ali, Lordship, he was arrested on 1/2/2025. That's been 52 days, Lordship, and this is the first application, Lordship. His petition was not earlier rejected, Lordship. He is for the first time.
Okay, all right. This is a common order for these 2 items. Both these bail applications are filed under section 483 of the BNSS 2023, whereby the petitioners Aizal Haq alias Muhammad Aizul Haq, Muhammad Zahirul Haq and Muhammad Rustam Ali have prayed for releasing them on bail after they were arrested in connection with Jagirid PS case number 249 of 2024. Para. For the petitioner Aizal Haq alias Muhammad Aizul Haq and Muhammad Zahirul Haq, these bail applications are filed for a second time after their earlier bail applications were rejected by this court. Para. It has been pleaded that these 2 petitioners have already completed 86 days in judicial custody, and the learned counsels, Mr. S.M. Mullah as well as Mr. S. Munir have submitted that their period of detention deserves to be taken up as a ground for releasing them on bail. The learned counsels part has submitted that some of the other accused relating to the present case were already released by this court on bail. I have heard Mr. Bankim Sharma, the learned additional public prosecutor for the state of Assam. Mr. Sharma has submitted that since no new ground has been pleaded in the bail applications, their applications need not be considered. But I have considered the submissions made by the learned counsels on both sides. This court has decided to agree with Mr. Mullah as well as Mr. Munir that the period of detention already undergone by them in judicial custody should be taken up as a ground for releasing them on bail. Therefore, the bail applications filed by Aizal Haq alias Muhammad Aizul Haq and Muhammad Zahirul Haq are allowed, Both these petitioners shall be released on bail of rupees 25,000 each, which should the like amount to the satisfaction of the learned Chief Judicial Magistrate Moriga, Assam. Para. The bail application of Muhammad Rustam Ali shall be considered on 3rd April. Accordingly, the bail application number 771 of 2025 is disposed of. List bail application number 541 of 2025 on 3rd April. The CD shall be retained. Okay, all right. Item number 15. Okay, two are allowed to go on bail. On third, I will consider the bail application of the other petitioner.
Lordship. On fiction, my lord. Third April.
On third.
Third,
For Rustam Ali.
My lord,
For
my lord,
CD retained.
my lord, 1 and 2, my lord, my objection is recorded, my lord.
Yes, I have recorded. I have recorded.
Obligement. Obligement.
Okay, all right.
Much obliged, Your Lord.
Item number
Much obliged.
15. Yes, item number 15.
Your Lordship, here, the petition, criminal petitions filed under 482 petitions. Your Lordship, the 15/2/2024, Your Lordship, the incident happened at.
Okay, show me the FIR.
Yes, FIR, your Lordship. Page 14, Your Lordship.
14.
Page 14. This is the FIR. This is the Nangda Pana. This is the informant, Your Lordship.
Under what section the case is registered?
Yes, Your Lordship. After
325.
Initially 341, 325 of IPC, and the charge was later on, Your Lordship, after filing of the charge sheet, charge has been framed under 326 of IPC.
Yes.
The court framed the charge.
Yes, Your Lordship. It
was filed under section 325.
Initially, it was filed under Your Lordship 325, 341 and 325.
Charge sheet filed under what section?
Charge is filed under 342/325 201.
342, 325, 201 of IPC, Your Lordship.
Okay.
Page
It's in page
25.
number
Your Lordship.
25, Your Lordship.
Page 25. Therefore, under the above fact and circumstances, the prima facie case under section 342/325/201 IPC is found well established against Sri Shivaji Tajuddin.
And Your Lordship
Yeah.
will find in page 50 the charge framed under 326, trial commenced. Page 50, annexure 5, Roman.
What type of injury is sustained?
Grievous, Your Lordship.
Your Lordship, Gravius stated that weapon of offense broken bear mark.
Broken beer mug.
Yes.
Oh,
This is why they altered the 325 to 326.
now they have compromised.
Yes.
Is there any
Your Lordship, before charge sheet, the parties compromise. That is 22 to 24.
No.
After within 1 week, Your Lordship, they have amicably settled the case.
What do you say?
Page 15, your lordship, the amicable settlement copy.
Can it be questioned?
Yes, your lordship, the earlier also the one judgment of the Honorable Supreme Court, 2025 SCC online, SC is page 38, your lordship. This has been referred, your lordship, but your lordship, if we go through the judgment, your lordship, no doubt Honorable Supreme Court on post conviction also 326 was, your lordship, compounded, was compounded by the Honorable Supreme Court. However, your lordship, not only on the basis of settlement, but the victim were, your lordship, sufficiently compensated, your lordship. So now here in this case, whether they have compensated or not, your lordship, because the fact and circumstances has to be taken into consideration, your lordship. No doubt 226 has been quashed, but under what aspect? First is compromise, compensation, and then, your lordship, the settlement by the parties. Settlement is there here in this case. But now the question here is whether they have compensated the victim or not, because ST says everything was there, your lordship.
But the victim himself has come here.
Your lordship here.
And your lordship, they have also compensated. Your lordship will find in serial number 10 of their settlement, page 17, your lordship.
Page 17.
Yes, your lordship. Point 10, your lordship. Clause 10, page 17. That any provocation from anyone related shall be liable to pay. This now they have settlement has been done on a conditional ground that later on, if anything, any default has been done by the parties, then they have to pay 10 lakhs rupees, your lordship.
Where page number?
Page number, your lordship, 17.
Page number 17, something else.
Actually, there will be, your lordship, two petitions. One was, your lordship, actually there was a defect. Later on, they were directed by this honorable court to file a corrected one.
I just saw it. Deed of settlement.
Yes. In my copy is page number, your lordship, 15 onward, your lordship. Annexure 2.
16, page 16.
In my 15.
Annexure 2.
Here the page 16 is the final report, charge sheet.
Then, your lordship,
It is here, the affidavit.
Yes.
In the stamp paper.
yes, your lordship, in the stamp paper.
No.
Your
Where
lordship,
it is mentioned?
Your lordship, point 10, but your lordship, it is not the compensation, but the condition that if either of the party violate the condition, then they will liable
That
to.
any provocation from anyone
Yes, your lordship.
or related to any party shall be liable to pay fine of rupees 10 lakhs to the aggrieved persons. In case of any provocation.
Yes, but still your lordship has rightly pointed out, your lordship, even if compensation is not done, but party has entered into an agreement, your lordship, still there will be a remote and bleak chance of conviction.
your lordship, kindly see para 4, your lordship, by petitioner.
Para 4 of the application.
Para 4, your lordship.
Settlement.
Para 4.
Oh, para
No, petition, para 4.
in the petition.
Yes, yes. That due to
Just a minute.
that due to intervention of the elders and relative of all the party, the case was amicably settled on 21/2/24 at Hotel Momsi, Itanagar among the parties without involvement of any compensation, out of mutual understanding and mutual cooperation. On the condition both the parties shall bear their own medical expenses. Your lordship, here the other party also beaten to the this alleged accused person also here. That is why they have taken own responsible to their own medical expenses. And agreement is a step also kindly see, your lordship, page 16, your lordship. Page 16. Now the deed of mutual agreement witness is under 1/6.
Page 17. Here.
16. 1. That the matter is settled among the party without involvement of any compensation out of mutual understanding and mutual cooperation. And para 4, that both the parties shall bear their own medical expenses and no party shall be held liable for any health hazard or oblique future complication of the other parties.
The parties have compromised.
Yes,
It
yes.
is quashed.
That's right.
It is quashed.
No.
Quashed and disposed of.
Obliged, your lordship.
60.
This is a lordship, statutory appeal,
This second appeal is,
second appeal.
second is a substantial question of law. is required.
Yes, yes.
What is the substantial question of law?
Substantial question of law, this, number one is this order 1 rule 9. The court cannot dismiss this appeal on the ground that the necessary party, there is a wrong interpretation with the necessary party in the case.
Yeah, where is the
There is the
judgment?
proper party.
Show me the judgment.
Kindly. Judgment is page number last, yes. Page number 123, annexure 2.
123.
Yes. Court has considered the proper party as a necessary party. On the technical ground, case has been dismissed.
Oh,
This is the issue.
Order 1 rule 8 provides that
Order
one
1 rule 9, the court cannot dismiss the suit.
person will defend on behalf of group having
At-
same interest in representative capacity with the leave of the court. Before giving that of filing the others.
At least it says notice may be issued to the parties, and when the party appear, this substantial question of law may be framed.
Heard Mr. T. Tapak appearing for the appellant. The present appeal is admitted for hearing upon the following substantial question of law. Below, number 1. Whether the dismissal of the suit by the trial court on the ground that without taking leave, the appellant filed the suit in a representative character under Order 1, Rule 8 of the Code of Civil Procedure. What did you write? Read. No, whether? What did you write? Whether dismissal of the suit by the trial court. Or without taking leave of the trial court. The appellant filed the suit as in representative character under Order 1, Rule 9, 8 of the CPC, comma, is bad in law.
My substantial question of law is lordship, page number 18, and this para 8.
Para, the appellant shall be at liberty to raise any other substantial question of law at the time of hearing of the appeal. Para. Issue notice to the respondents.
Yes, two respondents is here.
The appellant shall take steps for service of notice of the respondents by registered post with AD. Least up to 4 weeks till returnable date.
No,
What is the date of judgment?
Day of this judgment is lordship last
till returnable date.
Yes.
The judgment dated 04/02/2025 passed by the district judge Papumpare district, Arunachal Pradesh, UP. In what is the case number?
Case number is 02 civil appeal number 02 2022.
Is it a money suit?
Money shoot.
In money suit number 85 of 2018,
Yes.
shall remain stayed.
May I please, Your Lordship?
This will be taken up next week.
Your Lordship, at this stage,
Your Lordship,
appeal may be
let-
admitted and trial court may be called for you.
Actually,
actually,
the-
they have to
Your
be
Lordship,
admitted.
what has happened in this case, Your Lordship, earlier they prepare an appeal and because of some defect, they withdraw it.
Oh, okay.
And then liberty has been given, now they again file the appeal. So Your Lordship, this appeal may be admitted and called for the record. And Your Lordship, you should notice to the, Your Lordship, victim family, this is family, Your Lordship.
Yes, yes. Heard, Mr.
IBAM, Your Lordship.
IBAM,
Yes, Your Lordship.
appeal for the appellant. Heard, Mr. T. They learned it additional public prosecutor for the state of Arunachal Pradesh. The appeal is admitted for hearing. Issue notice. No formal notice is required to be sent to the respondent. But where is the respondent number 2?
Your Lordship, they have not implemented. However, Your Lordship, through Your Lordship is well aware of the Jagdish Singh matter case, matter. There is a judicial inroad has been made where the victim participatory right has been recognized. So basing on that, Your Lordship, the notice may be issued to the, Your Lordship, this is family, Your Lordship. Because since they have a participatory right, so without issuing notice, they will not inform that whether the case has been instituted before this court. Your Lordship.
No formal notice is required to be sent to the respondent as because Mr. Ate has accepted notice. Extra copy of the memo of appeal shall be provided to them, provided to him. Para. The appellant is directed to serve a notice of this appeal upon the informant.
Your Lordship, victim family, Your Lordship, this mother is there, Your Lordship.
Upon the mother of the victim.
Yes, Your Lordship.
Through the office of the public prosecutor. Call for the LCA. List after 4 weeks.
And Your Lordship, as well as registered post, Your Lordship.
Through the office of the public prosecutor, as well as the as well as by registered post.
Yes, Your Lordship.
Your Lordship, next day we fix for the hearing of the I. I has been filed for the suspension of the sentence, Your Lordship.
After service of notice upon the mother of the victim, the connected I shall be considered.
Yes, Your Lordship. TCR call, TCR maybe.
Call for the LCA, list after 4 weeks.
Yes, sir. Deeply obliged, Your Lordship.
Is it a pending case?
Yes, it is a verge of completion, Your Lordship. It is for hearing, Your Lordship. Earlier, Your Lordship, actually what has happened, the concern now, the session court, by the time when he was CGM, he has recorded the confessional statement. So now he is find some awkward things and he is find difficulty. So he write a reference before this honorable court, wherein the honorable Chief Justice has considered application and directed him to proceed with this matter. So now the matter is for the final disposal, Your Lordship. Evidence, now it's in evidence, everything has been done. This is for final disposal of this case. So at this stage, Your Lordship, this bail application may not be considered, Your Lordship.
Now, all the witnesses examined.
Yes, all.
Yes.
All witnesses examined.
Yes, yes.
Then you have to wait for some time. Let the trial court pass the judgment.
But Your Lordship,
After that, you have to come.
the ground, the ground which I have raised is that it has been pending for more than 4 months. Because the learned session judge, he recused himself from taking of the matter. Your Lordship, may please come to page number 188 of my application, Your Lordship.
No, now you are not entitled to bail. You have to wait till the trial court delivers the judgment. After that, you come. Heard Mr. K. Your
Taja.
Ketaja.
Ketaja.
Ketaja, appearing for the applicant, heard Mr. T. Ate, the learned additional public.
Your Lordship,
State of Arunachal Pradesh. Where this is an application under sections 483 of the BNSS 2023. In respect of sessions case number 54 of 2014. Pending in the court of where it is pending?
Session Judge.
Session Judge UPI.
Sessions Judge UPI. Para, Mr. Ate has submitted that all the prosecution witnesses are examined. All the prosecution witnesses are already examined by the trial court. And the case is pending for final disposal.
Yes.
Para, I have considered the submissions made by the learned counsels of both sides. Since the case is pending for final disposal, comma, this court is of the opinion that at this stage, the bail application of the petitioner need not be considered. For the aforesaid reason, the present bail application is closed and disposed of.
Deeply obliged.
Number one. Yes.
May I place you? This is. That's a bail application for the release of arrested accused person in connection with ROPS case number 78 of 24 under section 21A, 27 small a and 27 capital A of NDPS Act.
CD will be required.
Yes, Your Lordship. All
Without
party case
CD
area.
Otherwise,
I will call the CD.
if my lordship, if it's okay. Your Honor.
Heard Mr. K. Lolen, appearing for the petitioner, heard Mr. T. Ate, the learned additional public prosecutor for the state of Assam, call for the case day, state of Arunachal Pradesh. Additional PP for Arunachal Pradesh, call for the case day, when did the I will come?
Let it be, can it be on 28th, Your Honor?
It will take time, Your Lordship.
28th,
At least 1 week.
1 week, it's today is Tuesday, 28th is Friday, Your
on 28.
28. Deeply obliged.
Item number 19. Notice served or not?
Yes, Your Lordship, notice has been served.
Notice served.
Yes.
Service report in
Still awaited.
respect of respondent number 5 and 7 is still awaited. And then you have to wait. Hard MS,
K. Yadi,
appearing for the petitioner, hard Mr. G. Tadu. The learned traditional public prosecutor for the state of Arunachal Pradesh. Seen the office note dated 24/03/2025. Await for the service report in respect of respondents 5 and 7. List after 4 weeks.
oblige.
Yes.
Lordship, service report in respect of respondent number 1 is still awaited.
Complete or not? Oh, where are you? Entry board of entry board of entry board of the entry board of past will continue until. Yes. Notice not yet served.
Yes, Lordship.
What you will do?
Respondent number 1, Lordship.
Respondent number
1.
1. Not yet served.
Yes.
What about 2?
2 is already
served.
Yes.
Complaint case. Is it a complaint case? Heard, mister?
Yes, Your Lordship.
I pay for the petitioner. Seen the office note dated 24/03/2025. Await for the service report in respect of respondent number 1. List after 4 weeks.
Lordship, interim order is there.
The interim order partial will continue until then.
I beg your pardon, Your Lordship. Lordship, I beg to mention item number 19. There is also an interim order.
I have already passed it. Don't worry.
Oblige.
Ma'am,
Yes.
Madam, by order dated 27th of January 2025, I was directed to take steps for service of notice upon the respondent through usual course as well as through dusty service. Now, on 29/1/2025, notice was issued from registry. Thereafter, I made several efforts to serve notice upon the
appellant. The learned counsel has submitted that though he was allowed to take steps for service of notice upon the sole respondent by Dusty, in spite of his best efforts, he could not serve the notice. The learned counsel submitted that the respondent has intentionally refused to accept the notice and proceeding further with the execution of the impugned judgment. Para. I have considered the submission of Mr. So-and-so appearing for the appellant. What is the execution case number?
execution petition number 03 of 2024.
Then do one thing. Para. Under this circumstance, it is hereby directed that the execution proceeding relating to the divorce suit number 13 of 2022 pending in the court of district of Bomdila shall remain stayed until further order. List this matter after 4 weeks.
Much honor.
Your Lordship, CD was called for, actually there was a 2 FIR. In 1 FIR, a final report has been filed. And just to ascertain whether in the present case, whether there's a final report filed or not. So Your Lordship, final report has not been filed. Investigation pending.
Pending.
Yes, Your Lordship. They have come on the mutual settlement, Your Lordship, for quashing the matter.
Okay. Lordship, where is the FIR here? Show me the FIR. Page number. Probably page number 20. Is it 20? 21.
20.
It's 24.
24, Your Lordship.
24.
Yes. And the FIR of the 21 has been
21,
culminated into FIR.
Culminated into FR. And this FIR is to be
This
passed.
is,
And mutual settlement has been done. What is the police case number? PS case number? 148 of 2024.
148 of 2024, Your Lordship. Under section
148 of 2024.
Yes, under section 333.
What is the police station?
Ita PS.
Ita PS.
Itanagar police station.
Itanagar police station.
The FIR lodged by Pisapriya ended in final report.
Yes, Your Lordship. They have filed IA to that effect, Your Lordship.
For what?
For actually, they're supposed to file additional affidavit, but they file IA informing, apprising this court.
Oh, it's. I'd like to inform you that.
May I read the FIR, Lordship?
It is a fight between 2 women.
It's a fight between 2 women. One of the women is the sister of the other woman.
Oh, both are sisters.
No, the one woman which entered with the fight was in relationship with the husband of a woman.
Oh, it's okay.
Having an affair.
I understand. Now they have compromised.
Yes, Your Lordship.
Okay, it is first.
Yes, Your Lordship. Obliged. Your Lordship, here we have received in this case, the earlier case, CD was there, Your Lordship. In order, it may be reflected, the CD return.
CD shall be returned.
Yes, sir.
Yes.
In this interlocutory application, Lordship,
IFO, what extension of time?
Not extension of time, Lordship, for this, allow me to, Lordship, this, execute bail, Lordship. My
extension of the interim order.
interim bail order was
No.
recall, Lordship.
No, what will happen?
There was some specific order, kindly see,
No,
Lordship.
he did not appear in spite of that order.
Lordship,
This
that is-
interim was already Lordship, it is called back Lordship.
Interim is already called back.
Yes, Lordship. That-
Lordship, it was very short time to, kindly see this, as per this order, I was unwell, Lordship. Kindly see this page number, annexure 1, page number 8. This is the order, and operative portion is page number 9. This is the condition.
No, Mr. Tapak,
Yes,
your client does not take your advice. That is the problem.
Lordship, due to ill health, he could not come in that point of time. That is why that that particular death fixed by the court has lapsed. That is why, and he was ill.
No, I had extended the time earlier on the earlier occasion also, but he did not appear.
No, this is not the case. This is another case, separate case.
So this is separate case.
Yes,
Who
not
is-
that one. That has been already dismissed.
Where is the order?
Kindly see page number 8, annexure 1.
Page number 8.
Annexure 1. Kindly see this order was passed on 23 December 2024 during the court vacation hour. It was
Then
last, I
when
think
it
it
was
was last
recalled?
court.
When it was recalled?
And I was supposed to be order was on 23, and I was supposed to be on 31 till 31 December 2024. I was to be reported to the IO of the case for investigation. But due to ill health in that point of time, prescribed period, I could not be reported to the IO. That is why later on, Lordship, as per this order dated, kindly page number 11, annexure 2, order dated 14 February 2025, that bail interim order has been cancelled, saying that this court order within the prescribed period, I could not
Okay,
report.
all right. Heard Mr. T. Tapak.
I may be allowed to report to the
Petitioner. Heard Ms. L. Hage. The Learned Additional Public Prosecutor for the State of Arunachal Pradesh. Para. On 14/02/2025, in AB number 149 of 2024. Oh, no, not 14. On 23/12/2024. In AB number 149 of 2024, this court allowed the petitioner the interim bail and also directed the petitioner Mustab Ahmed to appear before the police investigating officer before 8th of January 2025. Thereafter,
Before 31st of 12/2024 also.
Before
31st of 12/2024.
Before 31st of 31/12/2024.
Yes, Lordship.
But he could not appear before the investigating officer
sir.
within that time. Therefore, he filed another prayer in this court on 14/02/2025,
Yes, Lordship.
seeking extension of time for appearance before the investigating officer. Stop. The petitioner cited medical grounds, but this court was not satisfied and rejected his prayer for extension of time.
And the interim bail was granted as recalled Lordship. And interim granted was recalled Lordship.
And
that day.
interim bail granted on 23/12/2024
Lordship, then since from that day he was awaiting Lordship, arrest Lordship. And
was recalled. We have to do one thing before appropriate bench, because there is a notification of the High Court.
Lordship, he's the main accused Lordship. And he,
I'm telling Mr. Tapaki, you should make this prayer before
yes, Lordship.
Justice Ate.
This is Justice Ate's record.
Because it's already
He
recalled
recalled
Lordship actually, yes,
He
Lordship.
recalled it, so if you want restoration of that order,
Yeah.
interim order, you have to apply before him. I will say just heard Mr. T. Tapaki querying for the applicant, heard MS L. Hage, the learning traditional public prosecutor for the state of Assam, list this matter before the appropriate bench.
Right.
Number 25. Yes.
Your Lordship, this is a joint petition, Lordship. This is a joint petition, Lordship. And regarding that, Lordship, there have FIR as Lordship.
Then why it is pending so long?
It is pending so long because of that, Lordship. For
Lordship, 307 is there. Attempt to murder, your Lordship.
That Lordship,
I
according
have
to
already passed many orders today.
Yes, your Lord.
List this matter next week. Next week, Lord.
Obliged.
Lordship, maybe release after 3 weeks, Lordship.
List this matter after 3 weeks.
Thank you, Lordship.
Number 26. Yes.
My lordship,
I have for what?
I have for condonation, second appeal,
How many days delay?
341 days.
So notice will go now. Heard, Mr.
K. Mubam.
APA for the applicant. Applicants
Yes.
issue notice to the sole respondent. The applicant shall take steps for service of notice upon the sole respondent by how we will send the notice by registered post.
We have taken through AD and usual post, but the same has not been delivered. So I pray that Dusty service may be allowed.
By Dusty.
Yes. your lordship.
Serve the notice upon the sole respondent by Dusty. Oh, oh, earlier you have taken steps,
Yes, your lordship.
not yet returned. But there are no office notes also. Then it's served by Dusty.
Yes.
Least after 2 weeks.
Obliged, your lordship.
May I please, Your Lordship?
I asked for what? Condonation.
My lord, condonation of notice for
The same order notice will go.
my lord,
How many days delay?
my lord.
How much is the delay?
Delay of, madam, total delay is 39 days, my lord.
39 days.
My lord,
Still the notice will have to go.
my lord.
Heard Mr. M. Kato. The learned additional Solicitor General of India. Deputy Solicitor General. of
Deputy, my
India.
lord.
Appearing for the applicants. Issue notice to the respondents. How you will send the notice? By registered post.
By registered post, my lord.
The applicants are directed to take steps for service of notice upon the respondents by registered postal cable, at least after 4 weeks.
My lord. Deputy,
My lordship. Lordship, this is a joint petition, lordship, for quashing and setting aside of the FIR, lordships.
But why it is pending for so long?
Lordship,
The CD was called for updated case study.
lordship, CD.
CD was called for.
Yes, last occasion CD was called for updated case study.
But lordship, CD also it's not required, lordship. This is compromise, lordship.
Show me the FIR.
Not lordship, only one FIR. FIR, lordship, phase 18, lordship, type copy
19.
19, lordship.
Could you please read the FIR?
May I read, lordship? Page 19, lordship.
With due respect.
Yes, with due respect and humble submissions, I have informed you that I am the father of victim, Miss
so and so, who is right now serving as nursing officers at General Hospital Alor, that last night my daughter had informed me through telephone that in the night she was performed duty with her colleague for COVID-19 at emergency ward at General Hospital Alor at about 10:20 p.m. The aforesaid Alice person illegally entered into the premises of General Hospital Alor and physically assaulted my daughter near emergency ward without any reason and provocation. In the view of aforesaid fact and circumstances, I highly requested Your Honor to kindly register a criminal case against the aforesaid Alice accused for criminal trespass.
Okay, now who are the petitioners here?
Petitioner number 1 is the accused person, Lordship.
Then 2?
And 2 is the complainant, Lordship.
Complainant.
And 3 is the victim, Lordship.
His daughter.
Yes, Lordship, daughter, Lordship.
Why they had compromised?
Compromised, Lordship, they are the family relative, Lordships. As a school classmate, Lordship, Lordship.
The petitioner number 1 is a school classmate.
Yes, Lordship. When they studied in the school, Lordship.
Under what section the case was registered?
Case was registered
323?
Yes, Lordship.
332. What is
Yes.
332?
322, Lordship.
No, 332.
323, Lordship.
No, what is 332?
332 is a voluntary causing harm to deter the public servant from his duty.
Oh, okay. And the core of Arunachal Pradesh Protection of Medical Services Institution.
Yes, Lordship.
Sorry.
That is, Lordship, in the act, Lordships.
Now they have compromised.
Yes, Lordship, we compromise, Lordship. Compromise, Lordships, annexed, Lordships, settlements, deed is available, Lordships. And Lordship make kindly favor, sir. Annexed, Lordship, 6 Lordships. This is settlement, Lordship.
Okay, Hage.
Yes,
They,
Lordship.
since they have compromised,
Yes, so they have compromised, Lordship. Then if yes, I leave it to the Lordship.
it is quashed.
Mashallah.
Obliged, Lordship.
It is finished. Okay then.